I want to turn it over to our host and presenter for today. This is Ashley Northrup from Sentry Management to get us started. Ashley, good morning.
Good morning. Thank you so much, Jeff. I just wanted to wish everyone a good morning and welcome to today's class. My name is Ashley Northrup. As Jeff said, I'm with Sentry Management. I'm part of our learning and development team. And I just want to say thank you so much to Alan Schwartzseid and Jeff for teaching today's class. Education is big for Sentry Management, and we really appreciate working with you. The class today, as Jeff said, is condominium based. So you're going to hear all about condo stuff. You don't have to worry about any kind of HOAs. And we really enjoy the two separate because that you know, if you're managing a condo, you want to know about condo stuff. So just a couple items. If you are with a Sentry managed community, your certificate, we will go ahead and upload that to your Community Pro profile within 30 business days. Jeff is going to provide some more information on how you're going to receive your certificate for your records after the class. And then you're always welcome to reach out to our team at learning@sentrymgt.com. If you can't find your certificate or if you need another copy, please feel free to reach out and let us know. With that being said, again, thank you so much, Jeff. Thank you so much, Alan. And we look forward to your class today and then future classes with you.
As Ashley mentioned earlier, our instructor for today from Kaye Rembaum over in the Orlando location, we have Alan Schwartzseid. Alan, take it away.
Thanks, Jeff. As you mentioned, my name is Alan Schwartzseid. I'm the managing partner for Kaye Rembaum's Orlando office. We do have other offices in Palm Beach Gardens, Pompano Beach, Tampa, and Miami by appointment. So we really do practice statewide. This is all we do is represent community associations. So condos like yours, HOAs, things of that nature. It's all the firms really done since the 1990s. So if you ever need counsel, we've got 20 attorneys, 7 of whom are board certified in this area of law, 1 of whom is board certified in construction law. So I know that that has become a major issue, especially with some of the issues we'll discuss today with your structural integrity reserve studies and your milestone inspection reports that are going to be coming up in the near future for many communities. It really does tend to help. We don't practice anything else. We don't claim to be a one-stop shop for everything that everyone needs, but we are a one-stop shop for everything that a condo may need, or a co-op for that matter. So if you're in the class today, you're welcome to stick around. If you're here for HOAs, just understand, as was mentioned earlier, I will not be talking about those except maybe 1 or 2 distinctions between HOA and condo law. But generally speaking, we appreciate you being here for getting some education. Sentry is a fantastic management firm. We appreciate Sentry and Ashley specifically having us here today. So without further ado, we've got over 180 slides to get through. So let's get started. Why are we here? I already got a question in the Q&A, whether this will count towards the new requirement that every director will need to take an educational class like this. When I say every director, I mean everyone that is on the board of a condo or a co-op is going to have to take this class. Maybe not with me, although I prefer it that way, but you're going to have to take a class like this. As of right now, those requirements won't go into effect until at least July. Right now, you have 2 options. One is to take a class like this. The other one is to certify in writing that you've essentially read the governing documents and you'll do your best to uphold what's in them. I think that piece of paper is completely worthless because, yes, you're certifying that you will do your best, but you haven't learned anything. And let's be realistic. If you've read your governing documents, there's a 99% chance that you didn't understand them because most of the time I wouldn't understand them. And this is all I've done for the last 15 years. But the important thing to note when it comes to this class, this board member certification class, is that every director in Florida must take a class like this and put their certificate into the official records of the association within 90 days, or sign that certificate and put that into the records of the association within 90 days. This is why you're going to have, if you're with Sentry, I believe Ashley said this will be taken care of for you. If you're not, make sure that you get the certificate at the end of the class. Jeff mentioned how you're going to do that. It's by filling out your survey and clicking on the link at the end. Okay, you're going to want to make sure that you get that, download it, save it somewhere so that you can get it to your manager or your secretary, and it gets into the official records of your association. Now, the other option is that you can have taken this class up to a year before you're on the board. So there are some people who are thinking about getting on the board. They take this class as kind of okay, really, should I be doing this or not? What are my obligations going to be? Because that's what we're going to talk about today. What are your obligations? The first one is to take a class like this, sign the certificate, get it to your secretary or your manager. Now, if you don't take this class, you are technically suspended from service once that 90 days expires. When I say suspended, understand I don't mean that you're off the board and you can never come back. What I mean is you are off the board gets to fill your spot if they choose to, but the better alternative is just take the class and get back on, and it's done. Now, this certificate needs to be kept as long as you're on the board, or at least 5 years. But you don't have to take this class as of right now for a second time, as long as you're serving on the board without interruption. What that interruption means is you're actually removed from the board. Okay, you're off. You've resigned, you've been taken off. We'll talk about some of the other things that might cause that to happen. Okay, so what we're looking at is make sure that you have this certificate in your official records, and that's it. If you've taken this class, you get the certificate at the end, you've done what you need to do. Now, I see that there are already questions coming into the Q&A. What I'm going to suggest is that you hold those, because chances are I'm going to answer a lot of your questions. What I will also ask, I've put my email address into the Zoom so that you can see just on my photo or on my video, my email address. Please do not email me during the class to ask questions. Okay. I'm almost at the point that I get so many of those that I might start ignoring them, because that's what the Q&A is for. You're in the class right now. There's no reason you need to be emailing questions. Anyway, moving on. Condos. What are we actually talking about here? Why does a condo exist? Because the Florida legislature says so. That's literally the only reason you're able to subdivide a building the way that you are in a condominium context. Keep in mind what statutes we're talking about here. Okay, when someone starts to quote Chapter 720 to your condo, unless you're also part of a master association, that Chapter 720 is completely irrelevant to your community. Chapter 718 is the Condo Act in Florida. That's going to control your association. The other one that will probably control, and I have seen some for-profit corporations that are under 607, most of you, I've literally dealt with maybe 3 or 4 in my career that are that way. Most of you will be under the not-for-profit statute that's mentioned here, Chapter 617. Okay, now keep in mind, both of those are going to control your association. They do occasionally conflict. When that happens, Chapter 718, which is the more specific law that governs your community, is going to control over Chapter 617. You've also got your Declaration of Condominium. This is the document that creates the condominium. Okay, it's not just legislature saying you can create it, but the actual Declaration of Condominium being recorded that creates the condominium itself. All owners own an undivided interest in the common elements. Common elements are what you probably consider as your common areas. Okay, now I'm going to skip through some of this stuff because frankly, we will get to it later in the seminar, but I want you to understand these are some major concepts that you need to understand. Chapter 718 and 617 both control your association. What that means for practical purposes is that you may have rights and obligations under Chapter 617 that someone that is not, and I can't use the word expert according to the Florida Bar, but someone that doesn't practice this area of law almost exclusively or actually exclusively on a day-to-day basis is not going to know some of these things that the association can or must do. So just be very careful with the management company you select and the attorneys you select to make sure that they know what they're talking about and that they are going to give you the best possible legal advice. Your attorney's going to give you legal advice. The other one won't. The management company doesn't give legal advice. All right, what can the association do? You're responsible for the operation and affairs of the condominium. You can institute, maintain, and settle legal matters. What that means is if something pertains to the entire community, you can deal with it without having to have every member of the community in that case as a plaintiff. Also, everything under 718 and either 607 or 617 of the Florida statutes, that is going to dictate powers and duties the association has as well. The general grant of power to a corporation is going to be under 607 or 617. This is what it entails. I'm not going to go through it in detail because you'll have the slides. And frankly, we have way too much material to get through. So you're going to see me skipping through some things. If I think it is crucial, trust me, I will get it to you. Let's see, which year's statutes apply? This is a crucial factor in a condominium in Florida. Generally speaking, the statutes that were in place when your declaration was recorded are grafted into that contract, because that's what your declaration is. It's a contract between the members and the association. Okay, but if a statute changes, let's say the statute that was in place when your condo was created in 1977, that statute changed at some time over the last, 50-ish years. Okay. That statute that has changed may or may not apply to a specific situation. Just because it's in the statutes doesn't mean it's controlling in a condo. The language that you want to look for, or more accurately, your attorney will want to look for in your declaration, is where it says that the declaration or the condominium incorporate the Condominium Act. In this language in purple is what's important, as amended from time to time. That's called Kaufman language for lawyers. Okay, that's what we call it. What it really means is we're incorporating every change that's ever made to the Florida statutes, regardless of whether we like it or not. Now, there are pluses and minuses to having that language in your declaration. You know, you might have statutory requirements that you didn't have to meet that you now do, but you also might have statutory rights that the association is entitled to that it wouldn't have under the original statute. So I'm not saying that having it or not having it is better or not. It's just a matter of making sure your attorney does the analysis of whether you have it and how that impacts your community. If a change in the statute is procedural, meaning, okay, well, you need to send this different notice before you have an election meeting, or you need to send this new notice of late assessment that pertains to collection of unpaid assessments before you can send an intent to lien letter. Okay, changes that are procedural only generally will apply regardless of what your declaration has in. When it's a substantive change, and this next slide will talk about that, but we also talk about it here. If it's a substantive change, then your attorney needs to look at this Kaufman language. If it exists, then chances are that substantive change is going to be adopted for your community. If it doesn't exist and your declaration doesn't say it incorporates the statute as amended from time to time, chances are that substantive change won't be incorporated and your declaration or the older statute will control that situation. Again, this is a complex legal analysis that I absolutely don't expect the board to do, and frankly would counsel the board not to do, and also would counsel management not to be undertaking this review. It should be your attorney who takes a look at this issue. But the important thing to remember, the pro tip out of these two slides, is don't assume just because it's in the declaration or that it's just in the statutes that this is what you have to follow. The bylaws may say differently than the statute. The declaration, your articles may say, the statute may say that this is the case XYZ, or it may say XYZ unless the bylaws say otherwise. Leave it to your attorney to interpret and know all of this stuff, because frankly, that's your attorney's job. Now, we also have conflicts fairly regularly between the declaration, articles, and bylaws. So how do you remember which one controls over the others? You're going to look at a little DAB, D-A-B will do you. This old this old ad. Okay. What we're looking at is in order of importance, in order of controlling, you have your declaration of condo. This is what some people call the CC&Rs. In a condo, you really don't have the covenants, conditions, and restrictions name on your document. It's going to be your declaration of condominium for 90% of communities or more. This is the association's constitution. It's the contract, like I said, that binds the members in the association. It's going to run with every unit in your condo. And in fact, almost always, you're going to have in your actual deed the reference directly to the recording information and the name of the declaration of condominium. So that's going to kind of renew the declaration every time there's a sale of property as to that particular unit. So understand this declaration, it's going to apply forever. So when someone talks about the Marketable Record Title Act, if you're in a condo and you have the legal description of the declaration in your deed, I'm sorry, the recording information of the declaration in your deed, that Marketable Record Title Act is not going to impact your community, except, like I said, if you've got an HOA that governs all of the master and your condo happens to be a part of that. But that would still only impact the master rights and responsibilities, not those of the condominium that you are working with today. So basically, you don't need to worry about that law, even though I wanted to make sure that it was mentioned, because a lot of people seem to be bringing it up as though it's pertinent, and it's not. The Articles of Incorporation is the next document in line. This is filed with the state. It's going to say the name and purpose of the corporation. Sometimes it'll say who the officers and directors might be. And that's really all that's going to go in there. A lot of times this is a very bare bones document that's really just intended to register the corporation that runs this community with the state of Florida. Now, I want to be clear because I haven't mentioned it yet. I mentioned that the Not-for-Profit Act applies, the Condo Act applies. Now I'm mentioning that the corporation is what runs the association. I want to be clear. You are running a business if you're on the board of your association. You are an officer, a director of a corporation, which is essentially a business. The fact that it's a not-for-profit doesn't change the fact that you are running a business. So you have to make business decisions when you are deciding things on behalf of the association, not emotional decisions or decisions that impact you differently than they impact everyone else, which could be a conflict of interest, etc. So I just wanted to make sure that we were clear on how, what your real responsibility is, which is to run a business. Your bylaws are going to be what most people think of that control the day-to-day operation of the association, your use restrictions, things like that. That's going to really be your declaration. Your bylaws are going to control how your meetings are run, who the directors and officers can be, what their duties and responsibilities are, things of that nature. So it's really, the bylaws are the day-to-day. The declaration is the overall operation of the corporation itself and the condominium itself. And then finally, it's not on this list, but your board-made rules and regulations. These are generally going to be adopted without a member vote, which means that they're scrutinized a lot more closely by the courts. There is case law that basically says what a rule needs to be. I'm not going to go through it right now, but I do recommend that. I know a lot of communities don't want to pay the price of having their counsel review rules and regulations that are adopted by the board because they can be changed so easily. But my concern is that I have seen directors put in rules and regulations that are not enforceable at all, try and enforce them, get with an attorney that doesn't necessarily know this area of law, and the attorney's response is, well, it's the rules and regulations of the association, so I'm just going to enforce it. But if it's something that's not enforceable for whatever reason, just understand you file your lawsuit seeking an injunction for enforcement of that rule, and you're going to lose your case and end up paying the other side's attorney's fees and costs as well as your own. So I would much rather see an association spend a couple $100 to a couple $1,000 making sure that these rules are enforceable versus spending tens to, up to $100,000 or more on attorney's fees in a losing battle, trying to enforce an unenforceable rule that they never really asked for counsel on. So moving forward, and keep in mind, if those rules are not supported by the declaration or the bylaws, if they conflict with the declaration or bylaws, the right answer is not to just put them in place anyway. It's actually to amend the declaration or bylaws so that they are supported, so that you can have your community be what you want it to be as a board of directors. And presumably the members, in most instances, I do have some sets of declarations and bylaws that don't require a member vote for amendments, but most of them do. So what you're saying is it's not just what the board wants that's going to be in the governing documents, it's also what the members have voted in favor for at that point. So it's the community that the members really want. If you're proposing this and the members approve it, that shows me that you're doing the things that the members elected you to do. So moving along, transfer fees and estoppel certificates. This is when someone sells or refinances a unit. Transfer fees are, generally speaking, they need to be in the declaration, articles, or bylaws. If you don't have a selling or leasing restriction in your declaration, my perspective is you need to amend before you adopt any kind of rules regulating that issue. I'm literally dealing with that with a client right now where they had a policy in place of requiring an application and an application fee before anyone was allowed to rent a property in the community for the last 20 years. But they're not actually allowed to do that because it's not in their declaration. So you need to be careful as to, okay, do we have the authority to do this? Once we establish that the association can do it, which again is an attorney opinion, you also can't charge a fee in connection with any of this unless the association is authorized to approve the transfer and a fee is provided for in the declaration, articles, or bylaws. So you want to make sure that if you're charging these approval fees, demanding that people submit an application before they can move into the community, and you're telling them you owe us some money because we're going to spend the time and spend the money to get a background check, you need to have that authorized in your governing documents. The fee can't exceed $150 per applicant other than a husband or wife or parent and dependent child. Those types of family groupings are considered one applicant. Okay. If it's a renewal with the same lessee, you can't charge. That doesn't mean, from my perspective, that you can't run the search at an association expense. You just can't charge the expense to that person. Security deposits, the association can request a security deposit or demand it, require it in an amount not to exceed 1 month's rent. So keep in mind, that is the max. If they're not paying rent, you can't require that security deposit. If they're paying $5,000 in rent, that's the max you can demand as a security deposit. It's going to protect against damage to the common elements. Once that person moves out, I want to make sure that you have either in your declaration or in the form that they fill out when they're paying this security deposit, you're going to want in there who gets the money back if there's anything left. I literally just dealt with this situation on a phone call with a client yesterday where they might have to file a lawsuit for a judge to tell them who gets this money. Is it the landlord or was it the tenant? Because if both parties are telling you that they are owed this money, then whoever you give it to, the other one, you're at risk of being sued. So you might have to file what's called an interpleader lawsuit to give the money to the judge and let the judge make a decision. And I'm not saying you're paying off the judge, just to be clear. I'm saying it goes into the court's registry, which is basically an escrow account for funds. And then the court will actually disperse the funds once a decision is made as to who gets the money between those parties. You don't want to waste $5 to $10 grand getting that lawsuit filed, getting the association dismissed, and getting your attorney's fees and costs back. It's just a waste when you could avoid it by basically including a line there that requires them to, the payment always goes back either to who made the payment or it always goes back to the tenant because presumably the landlord's not going to just make that payment for them, etc. But you want to designate who gets that money back. Anytime, by the way, that a deposit is being made that's being held by the association and it might be paid back, you want to make sure that you have a checkbox or something that says who gets that money back to avoid these issues. Estoppel certificates, it's basically a document that says here's what needs to happen for a buyer or a lender to give money or buy the property with a clean slate. What assessments are owed, which ones are going to come due during the time that this document's valid, what violations are on the property, and a couple other pieces of information. So this is a document, it's called an estoppel certificate. Within 10 business days after receiving the request, the association does need to provide that estoppel certificate, or you can't charge any fee, which we'll get into in a minute, for preparing the estoppel certificate. Now, keep in mind, the theory of estoppel is I can rely on this piece of paper to say that this is all that's owed and all that needs to be done in order for the new owner to come in with a completely clean slate. That means that if the closing happens and either the lender or the purchaser relied on that estoppel certificate, the association gets absolutely nothing that wasn't in there. So you want to make sure that it is 100% accurate. One of the things that I do occasionally see come up, although not with Sentry, is management doesn't know what the attorney's fees and costs are. For example, the association's on our special collection program, and they're not paying attorney's fees and costs as you go. They only get paid, including the out-of-pocket costs, once we close out that file. So we could be at $4,000 or $5,000 in attorney's fees and costs. You'll never have seen a bill as an association. So if management fills out, or you're self-managed and you fill out that estoppel certificate and you don't tell us, hey, I know this account is in collection, what are the attorney's fees and costs that you guys have incurred, so that we can send out a proper payoff that includes everything. If that's not included, remember what I said a minute ago, you're not getting it back if they close and rely on that estoppel certificate. The good news is, if this estoppel certificate is wrong, you can amend it as long as the closing hasn't occurred yet. Okay. It's good for 30 days, which means that during those 30 days, chances are you're not going to take a lot of action toward collection or enforcement, but you might just include that cost on the estoppel certificate. Okay. But it's good for 30 days. If it gets amended because you found an error or someone made a payment and you want to update it, that amended version is good for 30 days, and there's no charge for the amendment. Okay, so just understand, if it expires and the day after, let's say on day 31, hey, we need an estoppel, we didn't close yet, but we need a new one. That's a new charge from my perspective. So just understand, this needs to be delivered within the 10 business days, or the association gets no payment for it. That doesn't mean that your manager won't charge for it and your attorney won't charge for it. So make sure that your manager is doing what they need to do. I've never seen this as an issue with Sentry, never seen it as an issue with our firm. What I do see happening is what we'll talk about in a minute, which is the request is made on a rush basis and they're closing tomorrow. Sorry, but you're not entitled to that, even if you requested on a rush. We have 72 hours to produce that estoppel certificate. Okay, so the fact that the title agent waited way too long to ask you for this certificate is not the association's fault. It's not the association's problem. Here's just some content of what needs to go on this certificate. Unless you're self-managed, you're not going to be preparing it. If you are self-managed and you're a client of ours, I do have a form that I've prepared in the past that we basically just add the association name and some other collection related information, and you can use that form going forward. So I wouldn't worry about this content, what needs to go into it, because chances are, if you're with Sentry, Sentry's taking care of it. If you're self-managed and you're working with our firm, feel welcome to reach out to your attorney, and they should be able to prepare that general estoppel certificate form for you. Here are some of the fees that can be charged. I mentioned a rush fee. There is an additional fee that can be charged if they need it within 3 business days. If they say we need it tomorrow for closing, your response can be, I can't get it to you tomorrow. You should have requested it earlier. Now, keep in mind, in order to charge anything, you need either a resolution of the board, which is very easy. You can adopt that at any board meeting, as long as it's on the agenda, or a fee that is provided for in a management, bookkeeping, or a maintenance contract. So that is going to be included in Sentry Management's contract with the association, that they are going to charge that fee. Okay, so you're probably fine if you're with Sentry. If you're with another management firm, check your contract, or more likely just ask them whether that fee is authorized. And if not, have your attorney or your manager prepare a resolution for the board to sign so that you have the authority to charge those fees. You have to do the work regardless of whether you can charge for it. So from my perspective, don't give away that money and have every member of the community be responsible for that payment. By the way, that's what your legislature tried to do to everyone this year. But fortunately, that effort was thwarted. They wanted there to be no charge to the person requesting the estoppel certificate. And we argued that that could be a huge expense that all the members who have nothing to do with this transaction would then be responsible for. And fortunately, that effort failed. That was this legislative session. And now it was killed this year. Let's hope it doesn't come back. If the association delivers this late, like I said, you can't charge a fee for it. There's another issue that comes up with respect to estoppel certificates, and that's, like I said, they ask for it a day before, you don't provide it that day, and their argument is, well, you're going to lose us a sale. And my response is, no, you're going to lose us. Excuse me. Let me take a sip, and then I'll start that over. No, you're going to lose yourself a sale by not reaching out to us earlier. Now, what I do see as an issue is when the estoppel certificate is wrong and the association refuses to amend it. Okay, you should always be amending if you know that that information is wrong. There are laws that govern collection of debts that could be implicated there, but also the association giving a bad payoff could get the association sued. So we don't want that. If you are having multiple parcels, multiple units sold at the same time, there are different rates that have been established for those multi-sales. So just know you're not charging one estoppel fee per unit unless it's separately requested per unit. At that point, it's on them for not knowing they could have just paid the multiple fee. Reimbursements, if the sale does not close, then no later than 30 days after the scheduled closing, the person that paid requests a refund of the estoppel certificate, you have to pay that back. Or I'm sorry, a refund of the estoppel fee. You pay back the whole fee, but that gets added as an assessment against the lot or the unit. So just keep in mind, you know, you're not losing that money, you just don't have it in hand anymore right now. So don't go using that money either until you know that the sale was supposed to close and didn't, or the sale did close and the association got its funding or got a report of what happened as a result of that closing. Anyone that files a lawsuit regarding an estoppel certificate, whether it's a bad estoppel that contained inaccurate information, one not being provided, or failure to return these funds, is entitled to recover their attorney's fees and costs incurred. So you don't want to mess with that because those attorney's fees and costs can be way more than the estoppel fee. I promise you they will be before that lawsuit's even filed. This gets updated every 5 years. The last update was in 2022. So we expect it to be updated probably in July 2027. So the figures that are in these slides are probably accurate for a while. Like I said, it's good for 30 days if it's sent by email or hand delivery. I don't know anyone that mails these out anymore, but if you do, it's actually good for an extra 5 days that accounts for USPS being frankly kind of slow lately. Can't charge for the amended certificate. We talked about all that. So that's good. Moving on. You might get a request for additional information from the lender, or, you know, a lot of times this is from Fannie Mae, Freddie Mac, other lenders. If you're being asked for information that's not included in the statute and you're going to provide it, technically you can charge a fee of up to $150 plus the reasonable cost of photocopying records to support your response and any attorney's fees incurred by the association in connection with the response. This generally only happens when you're talking about a loan. I have not seen it happen elsewhere, although it is feasible. You're also going to include in any response to a written request that the responses herein are made in good faith and to the best of my ability and as to their accuracy. What that means is, sorry, but you can't hold me liable if this is wrong and I shouldn't have known that it was wrong. And usually that's going to be issued by your manager or your attorney. So it's not going to be the individual directors that are issuing that. You also need to have a condo Q&A sheet that's going to be prepared by your manager. If your manager didn't prepare it, then make sure that you get on them to do it. If you don't have a manager, make sure to put it together. It's specific to each condo, but it's fairly generic information, just specific to your condo. So make sure that you have that available. And the seller of that unit, although it's not pertinent to the association, unless the association is selling the unit, does have a duty to provide the buyer notice of all hidden defects. Speaking of defects, keep in mind when you're talking about construction defects, that statute of repose changed this past year, and it will formally change in July of this year. It's going to be reduced to 7 years. So you're not going to be able to raise that claim if that defect occurred more than 7 years ago. And sorry, lost my train of thought. If it occurred more than 7 years ago and a certificate of occupancy was issued more than 7 years ago. So if you've got any of those defects, I am not the guy that you want to talk to within the firm. That's Jeff Green. He is our construction board certified attorney. And I routinely refer clients to him, and I've never heard a single complaint about how he operates. So bottom line, if you've got those issues going on, I know there are many firms that are highly qualified and will do the work for your construction defects a little bit differently. That's totally fine if you want to work with them instead, but just know that if you're working with our firm, you do have someone that is board certified in that area of law and knows construction law in and out and deals with these issues on a daily basis. So if that type of issue comes up, don't ignore it, because you might be giving up your right, and you might not realize that you only have a year or so, or possibly less, after that developer turnover process is complete to actually do something about these problems. This is all about unit owner disclosures before the sale, so I'm not going to go through them in detail, but some of it is governance forms and the Q&A sheet that the association provides. So just understand there are some things that the association will need to provide, even though it's not a sale that's happening by the association. All right, get into a little bit of covenant enforcement, use right suspensions, voting suspensions, and fining. So I don't like fines. I think they're a waste of your time, because what they do is tell someone they owe you a bunch of money, and that's pretty much it. They don't get the violation cured. If the owner doesn't pay, chances are you're not going to collect on the fine. And it's mentioned, I think, in one of the next two slides, you can't even lien for it. So all you're doing is trying to get a money judgment for up to $1,000. That's worthless to the association from my perspective, unless you're doing it in conjunction with another lawsuit that's already being filed. And the lawsuit that should be filed if someone's not complying with their obligations is an enforcement injunction action or a collection action if it's the monetary obligations that aren't being paid. So I don't like fines. I think it's a cumbersome process that we'll go through in a minute. But if you choose to do it, here's what you got to do. And the same process is generally going to apply to use right suspensions for not paying, for non-monetary obligations. What does this mean? We're not talking about unpaid assessments. We're not talking about unpaid fines. We're talking about if someone goes onto your property and punches someone in the face, that's a pretty big violation. At least I hope it is. If that's not a violation of your covenants, you need to talk to an attorney about amending them. But let's say this person, does this. He punches another member in the face or another resident. Okay, that's a pretty big problem. And he's been screaming at everyone in the community ever since then. And it's nonstop. Does a fine stop that from happening? No, it does not. What you can do is suspend that person's right to use the common elements until they stop the behavior. Now, when I say the common elements, you're limited in what you can suspend. Okay, you can't stop them from accessing the unit. Any limited common element like a balcony or a parking space that is specific to their unit. And you can't stop them from going in elevators and things like that. What you can do is stop them from using the amenities. Okay, if you've got a special room in the clubhouse, they can't use it. If you've got a gym, you've got a pool, you've got a volleyball court, I don't know. If you've got something that is an amenity and is not a requirement of the association to be able to use their unit, you can generally suspend it. So you're not talking about suspending utilities, cable TV, if that's something the association provides and is paid for by the residents. You're not suspending probably, and this is questionable, internet access, if that's provided by the association. I would not take that risk. The risk I would take is that a judge is not going to understand, which there are very few judges that don't understand it now, that making them go through the gate and show ID instead of using a key fob is not restricting access. It's restricting one method of access to the community, and that is okay. But the process for suspending use rights and levying fines, and if you've got the right to do it in your declaration, suspending voting rights for violations starts with a board meeting. That's your typical 48 hours notice. Okay, we haven't gotten into the required notice for board meetings, but that's what we're talking about. 48 hours notice. You hold your board meeting, board votes to say, we're going to levy the fine, suspension, whatever it is. Then it goes to a 14-day notice of a hearing before a committee of at least 3 people that are not the directors, not the officers, not the manager, and are not any of their spouses or family members. Okay, that committee will then hold a hearing. It's not just offering it, it's holding a meeting and decide during that meeting whether to levy the suspension or the fine. If the answer is yes, then the board gives notice to the owner or the person that's being suspended or fined that the fine or suspension has been enacted, and it continues. From my perspective, the statute says a reasonable time. I say a reasonable time is until they stop messing around and they follow the guidelines of the association. Okay. If the committee says, no, I don't think it was that bad that he punched him in the face, and I think they're over-reporting because of that incident that he's been yelling at everyone in the community. So I think that we're going to let this go. I don't think it warrants a fine. Okay, no fine, no suspension. Whatever that committee decides is the end of it. That's it. Moving on. So we talked about who's on the committee. The fine can't exceed $100 per violation or $1,000 in the aggregate. No liens for fines. The fine is due 5 days after the date of the committee meeting. So what we're saying is you've been screwing around for the last 6 months. You owe us $1,000 that we're never going to try and collect. Or we could say you've been screwing around for the last 6 months and we're already in litigation to get a judge to tell you got to stop. And if you continue violating after that point, then you'll be in violation of a court order. Which do you think is going to be more effective in getting this person to stop the behavior? From my perspective, it's always going to be the typical enforcement, not just fining. Okay, we talked about use right suspensions. This pertains to monetary obligations. Okay, you can't fine for non-payment of a monetary obligation, but you can suspend the right to use those amenities like we talked about earlier. If you've got it in your declaration, the same thing applies, this process, to voting to suspend the right, to suspending the right to vote on association issues. That includes the election. It's going to include any amendment meetings, but keep in mind that's kind of a double-edged sword. When you suspend that voting interest, that means it doesn't count towards a quorum either. So you might have a tougher time reaching a quorum, even if that person would have voted against what you're trying to accomplish. But keep in mind, when we're talking about this suspension, the owner needs to be at least 90 days or more delinquent in any monetary obligation due to the association. Okay, that could be suspending because of fines. But essentially, you're going to suspend the right to use the amenities or the right to vote. That's going to last until the monetary obligation is paid in full. Now, if it's for monetary obligations, you do not need to have this second meeting. The board holds its meeting, provides notice, and then provides notice that the suspension was adopted. So keep in mind, these are different procedures based on whether it's monetary or not. Another avenue that some people don't think about, and it's right in the statute, the collection statute for condos, is a rent demand notice. If a monetary obligation hasn't been paid, the legislature says, okay, well, you know what? This person can't continue collecting rent without paying the association. The lender might not have that right. We really don't care. But the association has the right to say, whatever rent you're paying to your landlord, you need to pay it to us until we tell you you're paid in full, or we tell you more accurately that your landlord is paid in full with the association. If they pay in full, great. If they refuse to pay, keep in mind they're only obligated to pay what they would have paid the landlord that they haven't already paid the landlord. But if they refuse to pay, the remedy the association has, you can evict them. I don't think it's a great remedy because you're going to spend, what, another couple $1,000s to remove this person, and then you're going to have to do the exact same thing when the owner gets someone new in there. The good news is that's one more person that you can try and go after to collect the money that the owner owes. Now, the question becomes, because it's not clear in the statute, is the cost of that eviction also an assessment against the lot? The answer is, I don't know. So keep in mind, you may be spending more than what was owed to try and get this person out. I don't think it's a great remedy, but I do think that it's worth sending out that statutory notice to see what happens. Let's see. We talked about all of this. We talked about voting suspensions and the fact that it must be something that is authorized in your governing documents. If you don't have voting rights suspensions in your governing documents, you probably don't have the right to do it unless you have that Kaufman language in your declaration that we talked about earlier, that as amended from time to time language. For voting rights suspensions, it's a little different. Keep in mind that suspension must be for a debt that's greater than $1,000, and you also have to provide proof of the obligation that hasn't been paid to the owner at least 30 days before the suspension. So whereas with a use right suspension, we're just talking about 48 hours notice, board votes. Here you have some additional requirements because that voting interest is considered so important. All right, we talked about this. Member meetings. Okay, the annual meeting is really where you're going to have your election. Your bylaws are generally going to say when and where you hold that and how to call it. And if those bylaws are silent, you just have to hold it within 45 minutes of the condominium. A special member meeting is basically every meeting throughout the year of the members other than the annual meeting. Fairly straightforward. It's got a different name. It doesn't change anything other than it's not the election, or it's not the annual meeting. It's generally going to be called for a specific purpose. It'll usually be an amendment, a recall, waiving, or partially funding certain reserves. And it's going to require a written request of at least 10% of the community or whatever percentage is in your governing documents, or the board can set these types of meetings. Now, keep in mind, as compared to board meetings, the members are entitled to at least 14 days notice of all member meetings. The affidavit is required by the person providing the notice. That needs to go in the association's official records to prove that the notice was actually provided. That should be done for board meetings as well, by the way. Even the annual meeting notice must include an agenda. It might say open, accept ballots, move on, but it's got to have an agenda. Special meeting notice also needs to specify what is going to be discussed, what's on the agenda, not just new business or anything like that. And then there are other types of meetings. For example, a special assessment meeting, you need 14 days notice as well. So look out for issues like that. Don't just presume that no matter what, if it's a board meeting, it requires 48 hours notice. Now, electronic notice is only allowed if the member actually consented to it. So if you're sending an email blast to all of your members and thinking that that is a good enough notice of a meeting that's coming up, unless every single member of your community has opted into receiving notices via email or on your website, that's not going to be good enough. And even if they did opt in, that method can't be used for recall notices, for meeting notices regarding recalls, or votes regarding retrofitting condominiums with fire sprinkler systems. So look out for things like that. Hopefully your manager is aware, and if they're not, hopefully they're aware to ask counsel what kind of notice is required for the specific meeting that you're planning on holding. The owner is the one who's responsible, by the way, for designating those email addresses. The statute is clear. The association only needs to send that notice to the email address that was designated by the member. Okay, it's the owner's obligation, the member's obligation, to actually provide a proper mailing address or a proper email address. If they provide something, it changes and they don't tell you, that's their problem. All you have to do is send it to the last address that they provided to the association that's in the official records. Now, we talk about handicap access here. I'm going to strongly suggest, because we won't have time to get into it in detail today, that you check out our Fair Housing Assistance Animal or Pet course. This is going to talk about some of the major issues that come up in the Fair Housing Act, Americans with Disabilities Act, and dealing with disability-related requests. Don't think that just because something violates your rules, it's not something that you might have to allow someone to do. This is one of 5 or 6 policies I think every community should have, is how the association deals with requests to accommodate a disability. Okay, so there are 6 of them I really think everyone should have. We'll go through some of them today, but these are something that some communities will hire our firm just to have me go through their governing documents, which is the first step that I take in representing a community, get them over to the association, and then prepare these policies. There are some communities, because we don't require an upfront retainer, we don't require monthly minimums, we don't require an annual fee to work with the firm. They'll just use us for that or for second opinions, and we'll hear from them 6 months later, but they're using another attorney in the interim. I'd prefer to have all the business, but that's not required. All right, quorum. Unless a lower number is provided in the bylaws, the quorum is going to be a majority of the members. What that means to me, you want to amend that provision or add that provision so that you don't have to have a majority of your members attend every meeting just so that you can hold the meeting. You're not going to be able to hold a lot of meetings if you need a majority as a quorum. Member decisions generally require a majority of the votes during the meeting where a quorum is present unless the bylaws say otherwise. Keep in mind, just like board meetings, members have the right to attend and speak at all association meetings and to speak for at least 3 minutes regarding all agenda items which are open for discussion. So policy number 2 that I think every community in Florida should have is going to be one that restricts the frequency, duration, and time for member statements and member participation and member discussion, member interruption, almost more importantly, during those meetings. And just keep in mind, just because you don't have a problem with that issue now, doesn't mean you won't have one issue pop up where everyone wants to voice their opinion for 45 minutes and you can't conduct business as a result. So just be careful with how you do these things. I do recommend that every community in Florida have that member participation in meeting policy, because you really are unable to limit any of that speech if you don't have that policy in place. Keep in mind also, members can record those meetings. So if you see someone sitting there with their phone like this, they're allowed to do that. They can't necessarily share that recording with everyone in the world, but they're allowed to record it for their own use. The other thing to keep in mind, well, we'll save this for board meetings. Moving along. Voting by proxy is allowed in a condo. Limited proxies must be used for certain purposes, and they're going to be designated by the Condo Act. A general proxy is, hey, vote however you want. I'm just letting you take my vote. A limited proxy, which is what I just mentioned, is a little bit different. It's, you can vote on my behalf, but here's how you're voting. Basically, you hand in my ballot is what this limited proxy says, or you mail in my ballot, whatever it may be. If it doesn't say who the proxy holder is, usually that'll default to the secretary, so that the board basically gets, or the secretary in particular, gets to use those voting interests. We're going to skip through some of this. The other thing that we didn't mention, for both the board and the members, a written consent can almost always be used instead of having to hold a meeting. If you can get the required vote, it can be used unless the articles of incorporation say you can't use it. Now, keep in mind that written consent's good for 90 days, which means that you've got 3 months to gather up all the signatures you need to adopt whatever you're trying to adopt, to get that vote in. So this is authorized under Chapter 617. If you're looking at 718, you're not going to find that. You're going to find it in the not-for-profit statute. Okay. The board can also attend, by the way, they can attend board meetings and member meetings remotely. So just understand that doesn't mean that the association has a legal obligation to provide everyone the ability to attend remotely unless you're using electronic voting, in which event I'd be shocked if you're not using some kind of virtual attendance medium, because there's absolutely no reason that the members need to be at the meeting if they can vote on their phone. In case you couldn't tell, I am a fan of electronic voting. I think it gets a lot more, speaking of which, I guess next is elections. I think it garners a lot more of a vote of your members, which is obviously what you're trying to accomplish, because it makes it easier for people who are too lazy to send out a mailer of a proxy. It makes it easier when they don't have to leave their phone. If someone has to pick up a pen, there are a lot of people that'll say, let the rest of the members deal with this. I'm not one of them necessarily, but I do know plenty of people that will not vote even if all they need to do is check a box, write their name down, and mail it back to the association. So this electronic voting can be very helpful. To avoid disputes over the validity of the election result, make sure that at some point you formally close out the balloting. Okay, when you're having your election meeting, close out the balloting. That way you can actually count the ballots. Now, that's going to be a lot easier if you're using electronic voting. Your vendor's going to do that for you, but you're still going to have physical ballots that need to be counted. Okay, so make sure that you are basically checking and closing off the member's ability to continue voting. Usually that's going to be 15, 20-ish minutes after the meeting starts and you know you've got a quorum. The reason that I say it's around that time is that's about how long it takes to open the meeting, and I suggest leaving that voting open until you're ready to count the ballots. So you're going to open the meeting, go through the opening, portions of that meeting, the initial agenda items, and when you're starting the actual election portion and about to count the ballots, that's when you cut off the balloting and organize everything. There's no quorum requirement for an election. However, at least 20% of the eligible voters must vote in order to have a valid election. So you don't need to hit that majority if that's your quorum, but at least 20% of your members need to vote. Keep in mind, if you've suspended voting interest for this election, you are going to have a reduced number that you are required to hit, but also less people to hit it. If you don't need an election or you don't have an election, there are a couple reasons that might happen. One is you don't have the 20% of people actually show up and vote either by proxy, in person, or through the electronic voting system. Then the directors just hold over for one more year. You move on, you're done. You didn't have an election because you didn't need one. Another thing that might happen is you don't have enough people that have submitted their names as candidates or people that are eligible as candidates to require a vote. Voting by acclamation is essentially where you don't need an election because you have 5 open director slots and there are only 4 people or 5 people who've put their names in the hat. As soon as that 6th one put their name in the hat, timely, by the way, before the nominations had to end, because we're not in an HOA, there is a timeline on this, okay? If you've got 6, you need an election. If you've got 5, you don't. If you've got 6, but you didn't reach a quorum, there's no election, even though you're holding the meeting, okay? The condo election process is regulated by Chapter 718. It's also regulated by the Florida Administrative Code. Let's go through how this works. You've got 4 timelines here, and that's really the entire election process other than counting the ballots and announcing the result. Not less than 60 days before the meeting, you basically have to give a first notice and say, hey, here's when, where, and yeah, that's just when and where the election will be held. That's your first notice. It can even be as simple as one sheet of paper that says notice of annual meeting. And obviously it'll need to contain all that information in the association's name. No later than 40 days before the scheduled election meeting, everyone needs to put their names in the hat if they want to be a candidate. Anyone that hasn't done that, pardon me, within the 40 days is not going to be eligible as a candidate because they didn't do what they were required to do. Okay. No less than 30, or no, I'm sorry. Yeah. Not less than 35 days before the election, the candidates all give in whatever information sheets they want. This is one normal piece of paper that provides the information usually as to why you should elect that person. I've seen some that I don't like that are basically bashing other people. Unfortunately, the association has no authority to change or reject what's on that piece of paper. Okay. It generally needs to be something that is whatever this person, this candidate put on the piece of paper. You know, if it's nothing but bad mouthing someone else, I really hope you're not voting for that person because they're not going to be a courteous and helpful member of the board from my perspective. And then again, finally, your last notice is not less than 14 days before the election meeting. You're going to send your final notice, the second notice of the meeting. That's going to have the entire election package along with it. So that's going to include the written notice, the agenda for the meeting, the ballot listing all of the candidates who actually are eligible to serve on the board, and all of the inner and outer envelopes to enable people to vote. The election is decided by a plurality of ballots cast. Whoever gets the most votes wins. If you've got a vacancy on the board that's caused by the expiration of a term, that's filled by an election. If it's by resignation, you can go by appointment or election. You're going to go with an appointment of another director so that you don't have to hold another election for no reason. Something I have heard, which is absolutely wrong. Well, they didn't hold an election for the last 3 years, so anything they did during those 3 years is totally invalid. No, if you didn't need an election, that's why you didn't hold one. If you didn't have enough candidates or you didn't have enough people show up, you can't control that. The board just stays on. Now, you will have people that say, I've been on the board too long, I don't want to do this anymore, I resign. Fine. You then appoint someone to replace that individual. That's it. The official records from the election are maintained in the official records of the association. Any election challenge needs to be raised within 60 days after the election results are announced. Keep in mind, I've never seen it in person, but I know that there are instances where the election results are not announced during the meeting. I think that's doing it wrong, and that may be the basis for the challenge. But if the election result is announced 2 days after the meeting, because there's some issue and there needs to be, you know, a bunch of recounts or whatever. I think you're probably doing it the wrong way, but the election can be challenged up to 60 days after that later date. Candidate, the word that I've been using, just means someone that's eligible to sit on the board and timely submitted their written notice of intent to be a candidate. That's it. Anyone that wants to be a candidate needs to announce that intent in writing no later than the 40 days that we talked about. There are certain things that will keep people from being an eligible candidate. And essentially, it is a criminal conviction of a felony or something that would have been a felony if it was committed in Florida. And you haven't had your civil rights restored, meaning you haven't been out of prison for at least 5 years. Someone who's been suspended or removed by the division under the Condo Act, meaning you did something wrong regarding a condominium, you can't just jump back on the board. A person who's delinquent in the payment of an assessment due to the association as of the deadline to submit intent to be a candidate, meaning it's not as of the date of the election, it's as of that 40 days before date. Okay, can't be a candidate. If you are in a residential condo of more than 10 units or one that doesn't include timeshare units, co-owners can't serve as members of the board at the same time unless they own more than one unit or there are not enough eligible candidates. And then someone who becomes delinquent during their service on the board and is more than 90 days delinquent in the payment of any monetary obligation to the association, even if it's a fine, doesn't matter what it is, will be off the board. They're deemed to have abandoned their seat. So it's not a board decision, they're off. Now, keep in mind, when we say that these people are not on the board, they're not allowed to be on the board, they're removed from the board, etc. Any decision that was made during that time is still something that is going to be a valid board decision, presuming it was otherwise valid. You don't undo everything that director accomplished just because they shouldn't have been on the board. Okay, I understand the logic in thinking that that might make sense, but it's not something that Florida law does. Unless the bylaws say otherwise, the board's going to consist of 5 members. In a condo of 5 or fewer units, the board consists of at least 3 members. So usually you're going to have a 5-member board. I do represent some that are only 4 members. 3 of them are on the board. Condo term expiration is at the annual meeting. So your term will expire at that annual meeting. You will have term limits. Now, term limits is different from staggered terms. Staggered terms is basically, oh yeah, this director gets appointed or elected this year, a different one next year, and a different one the following year, so that you've always got someone who previously served and presumably has some knowledge of how the association operates, and that information can be passed along and shared among the directors. Term limits are statutory and basically say that you can't serve more than an 8 consecutive year term unless 2/3 of all votes cast in the election say that you can do it, or there are not enough eligible candidates to fill vacancies on the board. In practical terms, I have not seen this come into play yet because it was not made retroactive by the Florida legislature, meaning it doesn't officially take effect unless you've served 8 years as of it was 2018 that this was adopted. So 2026 is when this will actually come into play in practice. But what I've seen people do is drop off the board, get reappointed, and technically their service was interrupted. So that 8-year term limit doesn't apply anymore because it's not consecutive service. I don't think that's the intent of the statute, but you're always going to find people that try and skirt their obligations. Verifying outer envelopes. So you can notice a meeting of an impartial committee consisting of members who are not directors, officers, or candidates, who will then go through the ballots and verify that the outer envelopes, we talked about outer inner ballot. That's the order you go in. Okay, the outer envelopes are going to contain identifying information for the unit that's voting in this election. You can hold a meeting, this is what the first point here is saying, that will decide whether or not those ballots on their face are valid. Did this person vote more than once and they don't have multiple units, which will cause both of those ballots to be discarded or disregarded? Did this person have the right to vote at all? They're the resident, but they're not the member. That person doesn't have the right to vote unless there was some kind of assignment of the right to vote, either a proxy or something of that nature, okay? This committee is allowed to meet before the election so that you don't have to spend, I mean, we've got some communities that are 3,000 units, 3,000 lots. You don't have to spend that entire time, let's say half of them actually voted, counting 1,500 ballots or making sure that 1,500 ballots were actually entitled to vote before the during the election meeting, so that that's a 10-hour meeting. This committee can meet in advance and go through that information beforehand. The meeting needs to be open to all members. It cannot be a closed meeting. That meeting that I'm talking about, not the annual meeting, but the meeting where you're going through and checking all of the outer envelopes, needs to be open to the members with at least 48 hours notice posted in the community. The signature and unit owner and everything else on there, any outer envelope that's not signed by the voter must be marked disregarded. Literally handwrite it on the document itself. Any ballots that are in there are not going to be counted. Okay, so let me just briefly go back to the process when you're in your election, and we do have a separate class on this, so I'll be very brief. If you want to watch any of these classes, they are previously recorded. You won't get credit for it if you're a CAM, but you can get the information at kbrlegal.com under the resources tab. We have all of our previously recorded classes. This one will go up there probably in the next week or so. So back to the election process, you're going to open those outer envelopes that you've verified are good enough and go to the inner envelopes. Those inner envelopes should have no marking. My perspective is if they have marking, that person has just waived their right to be anonymous as to how they're voting. So once you've separated out all the outer envelopes and inner envelopes, if there's more than one inner envelope in there, make sure that that person doesn't have 2 votes. If they do, meaning they don't have 2 units. Okay, but if they're including two inner envelopes in one outer, chances are both of those are being discarded and disregarded. Once you've opened all of the outer ones and separated those out and kept them as part of the official records, you're going to open the inner envelopes and separate out the actual ballots themselves. Those ballots are going to be kept separately. Inner envelopes go away. Further anonymity. You're not going to shuffle them or anything, but they're going to be separated out. Then you're going to count the actual votes. If you're doing electronic voting, you're going to add those votes to the electronic votes, and then you get your tally for who got what number of votes and who wins the election. The officers, we haven't really talked about the distinction between officers, directors, and members. Your directors are the board. They're the people that actually make decisions for the association that aren't decisions made by the members. All they're going to do is make motions, second motions, discuss motions, vote on motions, or abstain from voting on motions because they have a conflict of interest. We won't have time to go through conflicts today, but we do have a class on that I suggest you check out because it is such an important issue that I think you should get the full hour, hour and a half, or whatever that class is, rather than the 5 minutes that I'd be able to talk about it today. I'd rather save the 5 minutes for something we don't have a separate class on as of now. So we talked about directors. Another hat that most people that are on the board are gonna have is that they are also a member. Those are literally just your unit owners. It's someone who owns property within the condo. Okay, and then finally you have your officers, what we're talking about now. Those people are going to have specific obligations set out in the bylaws or the articles of incorporation. They're essentially going to say, hey, this is what these people are responsible for within the community. You've got your president who's the mouthpiece and is going to basically sign the documents on behalf of the association. The secretary keeps the records, the treasurer is going to keep the dollars, but realistically, if you've got someone like Sentry working with you, they're going to be taking on most of the responsibility that the officers would have had. So you're still going to be responsible for interfacing with the management firm if you've got one, but chances are they're going to do most of the things that those officers are responsible for doing. So those are the 3 positions the association needs to have in order to be properly seated. The officers serve without compensation unless the bylaws say otherwise, and the board does get to change who the officers are. So that initial meeting to decide who the officers are is the only time that the board gets to vote by secret ballot. Most boards, pardon me, don't. Most of the time I nominate this person as president, they say yes, everyone votes in favor, and then you move on to the next position in line. I've very rarely seen an actual secret ballot used for this purpose, but it's the only thing that the board can vote on by secret ballot. Now, I mentioned that officers can be removed. You can't just remove a director by board vote. But the officers are a different story. You can tell someone you're no longer the president if the board puts it on the agenda and votes on it. This is how we usually control people who are what I call a rogue president, who's just deciding things for the association, signing contracts, but had no authority to do it, delegated by the rest of the board. They're just doing whatever they think is right, and that's great. But if they don't have the authority to do it, then they're putting the association in a bad position, because the other directors might not have wanted that contract, and now the association has to try and pay to get out of it. That's not a good situation. So that is one way to get a rogue board member to stop doing what they're doing, is to take away that officer position and say, you are now a director at large, or you're now the secretary and you have no right to sign contracts on behalf of the association. Things of that nature. So you can change those officers midstream. We talked about electronic voting. We have entire seminars on that, and the vendors put on seminars. I will say, I think it's helpful. The major thing that we generally will work on with the association is the contract with the vendor, and the fact that there needs to be a resolution that most of these vendors won't prepare for you, that needs to go out to the members so that they can opt into electronic voting, but mostly so that the board can adopt electronic voting. That needs to be with 14 days notice to the members of the meeting where the board plans to adopt electronic voting. So essentially, it's association attorney prepares the resolution, the board schedules a meeting and provides notice that it's going to be 14 days or more from the date the notice goes out. The board holds the meeting, votes to adopt it, and then the vendor is able to step in. The board, we talked about who you are. You're the directors, okay? Officers and directors. This is the most important thing you'll probably hear today. Officers and directors owe a fiduciary duty to the members as a whole and to the association, not necessarily to each individual member of the community, but to the association. That means you have to do what is in the best interest of the association and use your best business judgment, even if it will hurt you to make that decision, okay? It doesn't mean that you are automatically held liable personally if something goes wrong in the community. Okay, one of the things that I joke about, and I say the third most important bill you'll ever pay is your directors and officers liability insurance policy premium. That's the insurance policy that covers you guys, the directors and officers, if something goes wrong and someone decides to sue the individuals, not just the association. Now, when I say they're going to sue you or they might sue you, don't sit here thinking you did anything wrong or that you will do anything wrong. I can file a lawsuit because someone sneezed in the wrong direction 5 miles from my house. Okay, just because you file a lawsuit doesn't mean you're right or that you'll win. It just means that you have the right to get in front of a judge, or at least have a complaint filed in court. But I say that this is the third most important because I think your manager is your most important. They're going to keep you out of trouble. Your attorney is your second most important. They're going to keep you out of trouble. Your directors and officers liability insurance policy is when, well, we did our best to keep you out of trouble. You got into it anyway. Okay, so I think those are three things to keep in mind. And I joke to some extent about the manager and the attorney being more important, but you really should be relying on those individuals so that you can make the best business decision, not just an emotional one or the one that you unilaterally think is best for the association. The good news, this is the highest duty imposed by Florida law. The good news is that fiduciary duty being held to the highest standard under Florida law, you're actually held to what I call the dumbest person in the room standard, because the legal term is that you have a fiduciary duty to do what you reasonably believe to be in the best interest of the association. What that means is if you had a reasonable belief that what you were doing was in the best interest of the association, even if it was the wrong decision, even if it hurt the association, you should not be held personally liable for any wrong that occurred, any harm that happened to a member, any harm that happened to a vendor, any breach of contract, etc. It's the association that would be held liable for that, if at all. So again, make your best efforts to do what is really needed by the association. The board is the one that makes almost all decisions. So we've gone through that. I'll skip through it a little bit. This is an important one, and I don't think there is a very clear answer under Florida law. What is a meeting of the board? Now, the statute is clearly stated that a meeting of the board is essentially when the board meets and conducts business. Okay, but that's not the actual wording of the condo statute. That is the wording of the HOA statute. The condo is similar. So the condo is even less clear than HOA. My perspective is you're not conducting business if all you're doing is gathering information. If all you're doing is talking to a potential vendor about the services they can provide to you. It's when you're actually going to consider voting that you are conducting business and holding a board meeting. Now, the first requirement that is clear and I agree with is that a quorum of the directors must be present. So if you've got a 5-member board and you've only got 2 people in the same room and they're meeting with a vendor to decide whether to use that vendor and gather information, that's not a board meeting, period, under any interpretation of the law. So the question becomes, if you now have 3 directors in the same room, is that a board meeting? Well, it's not a board meeting if you're not even discussing anything association related. It's not a board meeting if you don't have a quorum. But you're going to need to get an opinion of your attorney, because that's the person that's going to be working with you, as to whether or not another meeting is going to be a board meeting or not. There are some that will say, if you're out on the golf course, you begin discussing having a party for the association and using association funds to do it. You're not going to make a decision today. You're just mentioning it to bring up at the next board meeting. That in and of itself is a board meeting, according to some attorneys. I disagree. That doesn't mean I'm right. Okay, there is a difference opinion among experts in this field about this issue. One thing that is clear also, there's no sunshine law in condo land. Okay, and condo land is the law of condominiums. It's just my word for it. But condo land has no sunshine law. That pertains to government operation and meetings of government. That has nothing to do with the association. What people are talking about is the obligation to have open board meetings, not closed board meetings, except for when that closed board meeting applies. So just keep in mind, you're going to have that openness whenever you're holding a board meeting, unless it is pertaining to legal issues that counsel is present for. And I don't mean just amending your governing documents. I mean, you're talking about potential or ongoing litigation, or you're talking about association employees. Okay, those are the only 2 instances where you do not have an openness requirement for board meetings. If you don't hold a board meeting and frankly, you screw it up or you make a decision on an emergency basis, there are a couple things you can still do to fix that problem. One, you can ratify the decision later on. Okay, you make a decision today to hire our firm. You're thoroughly impressed with my presentation today, and you call me and you say, Alan, get me a representation agreement. I want to sign it right now. Hopefully you've at least got the email approval of your board, which you can communicate by email. You just can't vote via email. But if the board decides that today, you can ratify that decision at the next board meeting by having it on the agenda, holding the discussion, acknowledging that the decision's been made, but going through the exercise of having the full discussion of, okay, well, here are the reasons we think this is a good idea, and then actually having the vote. The other thing you can do, and it's not listed here, I talked about that written resolution. The same thing applies to the board. Excuse me, let me take another sip. Lots of speaking. If the decision of the board is unanimous that you want to move forward with whatever the project is, the purchase, the service, whatever, you can have a written consent that is signed by all of the directors and is a unanimous decision. And it's a resolution unless the articles of incorporation say you can't do it, which I've never seen a set that does. But that will take the place of a board meeting, whether you're ratifying after the fact or you're deciding and signing before you actually sign that contract or sign up for that service or good. Okay. Keep in mind, this is another important one. Directors cannot accept a free lunch. Now, you can accept up to $25. You can accept things that you get at an educational program or a trade show, but you can't accept anything of value by a vendor that is proposing to provide goods or services to your community. Now, I will say, if you are on the board of a community association, I'm always proposing to provide services to your community. So I'm an example, and KBR is an example of you might be limited in what you can accept. The good news is a good lawyer, a good vendor is going to know that these limitations exist and not even tempt you to do it. Frankly, anyone that does tempt you to accept things like this is not a vendor, in my opinion, that you should be working with. Keep in mind, if you're charged by information or indictment, basically charged with a crime by police and by the court, with a felony theft or embezzlement offense involving association funds, you're out of office. That vacancy gets filled. And if you are found not guilty or the case is dropped, etc., you go back on the board to serve the rest of your term. If your term is over, you're just off, and that's it. That seat can be filled by appointment. So keep in mind, you might have someone filling your seat until that case is over against you. Board meeting generally requires 48 hours notices, except in the case of an emergency. That notice doesn't need to be mailed or emailed. It could be emailed, but it generally needs to be posted conspicuously in the community before the meeting for 48 hours. Now, if you have a non-emergency special assessment or an amendment to rules regarding unit or parcel use, or an amendment to the covenants, conditions, restrictions, the declaration, bylaws, etc., that's all going to require a 14-day notice, even though it is a board meeting. You do need an agenda for every meeting. If the members, if 20% of the voting interest petition to address an item of business, then within 60 days, you need a special meeting of the board to address that if it's something the board gets to vote on. So just like we talked about special meetings of the members is 10% earlier, this is 20% of the members asking for a board decision. And that meeting gets held within 60 days. Now, keep in mind, you put it on the agenda, that doesn't mean you have to vote on it. You have to discuss it, make a motion, but that motion could be, I move that we not vote on this issue today. That could be enough. And then they would have to give another another petition to address it again. Now, you should take these seriously because the next petition you'll get might be a recall if you basically ignore what your members want. But just keep this in mind that it is something that could happen. Don't think that you can just ignore those requests from your members. Just like in member meetings, the members get to attend. We talked about why I think you should have a policy governing these issues and how members can participate. So let's move on. Quorum is a quorum of directors at a board meeting. The fact that there are 300 members and only 20 showed up at the meeting does not mean a damn thing to me if 5 of them are the 5 directors of the association, or even 3 of them are the 5 directors of the association. So just keep in mind, you don't have to have a quorum of the members at a board meeting. Committee members, board members can attend those meetings by phone or by Zoom if the association is willing to offer that. So they don't need to attend in person. There does need to be a physical location where other people can attend if they want to, unless you've put something in your bylaws that say otherwise. The virtual board meeting thing is becoming more prevalent. Whether it's authorized or not is a different issue. What do a golem and a condo board workshop have in common? They're mythical. They don't exist. You can't have a workshop to get around the need for a board meeting. You can, in my opinion, try and gather information like I discussed earlier. Keep in mind, committee meetings might also need to be open to the members. If the committee is going to take final action on behalf of the board or make recommendations regarding the association budget, those are always subject to meeting notice requirements and can't be exempted. Any other meeting of a committee is generally something that can be exempted from notice. So just keep that in mind. There are committees that, just like the board, need to provide notice of their meetings to the entire community. Conflicts of interest are essentially where a director has a direct interest or has a family interest in the proposed contract or service. This is the only reason that a director is allowed to abstain from voting on an issue. Okay, so everyone votes yay or nay or abstains on every board issue, every board vote. You should not be abstaining, and frankly, my perspective is you don't have the legal authority to abstain from voting based on the fact that you don't like what's being discussed during that meeting. If you don't like it, vote no. Pretty simple. No, I think it's a bad idea. Yes, I think it's a great idea. Yes, I think it's a good enough idea. But don't abstain without a conflict. That's, from my perspective, that is not complying with your fiduciary obligation to make decisions on behalf of the association. Okay, but we're not going to get into conflicts like I mentioned earlier. We've got an entire class on them, but a conflict is essentially that there is an obligation to provide notice of the conflict to the members of the association. And there are certain things that the members are allowed to do to get out of the contract if the conflict wasn't disclosed in advance. So just keep all that in mind. Again, you will have access to these slides after the class. Keep in mind the director can present the contract. You just need a supermajority vote, and the director needs to actually leave the room altogether while the directors are voting so that there's no interference with the other director's vote on that conflicted issue. I'm on slide 63. We're at 12:30, so I'm going to breeze through some of this stuff, but we do have another full class on this issue. Criminal penalties now exist. These are ones you'll want to know about. Forging a ballot envelope or voting certificate used in a condo election, that's a crime. Theft or embezzlement of funds of a condominium association is a crime. Destruction of or refusal to allow inspection or copying of an official record of the association that the members are entitled to see in furtherance of a crime is in and of itself a crime, or obstruction of justice as provided in the Florida statutes. If a criminal charge is pending against an officer or director for any of these things, they are not on the board right now. If the charges are resolved without a finding of guilt, like I said earlier, that person jumps right back on for the remainder of their term. If there is no remaining term left because it took long enough, that it took 6 months for the criminal courts to make a decision, then sorry, but they're eligible for the next election. How to get off the board: resign, recall, be delinquent in payment of monetary obligations for 90 days, criminal charges, knowing and willful violation of the Condo Act, failure to satisfy the certification requirement, or if you die, you're also technically off the board. I really hope I never see anyone that is deceased that is still allegedly serving. So moving on, budgets, reserves, and financial reporting. This is generally going to be done by your accountant, your CPA, etc. What you need to know, especially if you're working with Sentry, is that they will do most of your accounting, but you might still need to hire your own CPA that works with Sentry. The most important thing that I can tell you, and I'll skip through budgets other than to say this: your budget is your best guess of what it's going to take to properly, and I mean properly, maintain and operate the community over the course of the next year. So you're going to make sure that the condo is well maintained and it's operated correctly. You're not going to say, well, we don't have the legal budget for that, so we're going to ignore those violations because we know we can't go after them. We're going to ignore this breach of contract by our landscaping vendor because we can't afford to go after them. We can't afford to have that reviewed by our attorney because we think that it's going to cost $2,000 to $3,000 on a $500,000 contract, and we can't justify the additional expense. We can't do the landscaping that we need to do. Well, you get to make that decision. If it comes up later, that's one thing. But the board does actually, I said you get to make that decision. My opinion is actually you don't get to make that decision, that you're not going to do that project this year unless it's not necessary. Unless the declaration, bylaws, articles, Florida law say that you don't have to do it, you have to do it. If your budget has to go up $2 million next year because of things that you're obligated to do, increase the budget $2 million next year. Okay. A lot of communities are going to have significantly greater reserves this year than last year or this coming year. Okay. That doesn't factor into the 15% increase that's found in the statute that a lot of people bring up as the basis to say you can't raise the budget this much. The board's responsibility is to ensure that the budget covers everything that you reasonably believe is needed to properly operate and maintain the community. The members then get to say, we want a different budget, but you as a director are going to comply with your fiduciary responsibility to ensure that the budget is proper. Let the members say, we don't like this budget. Matter of fact, point out to the members, our attorney or an attorney that we took a class with, even if I'm not working with you, I don't care, refer to me, that's fine. The attorney we took the board certification class with told us that we have to make the budget what it will really take to properly operate and maintain the community. We welcome you, and we hope that the members will propose a different budget. But this is us complying with our legal obligation as a board. Okay, you can't water down the budget to keep the assessments artificially low. The other thing that I don't want to see you do is you're halfway into the year and you say, well, you know what, our budget doesn't allow for this, so we're just going to back into what the budget says. We're not going to do the necessary maintenance. We're not going to do these projects, even though we really, really need to. Because keep in mind, those projects are going to cost way more if you wait. You want to look into a special assessment. You want to look into amending the budget. And you don't want to look into, well, this can wait for another 2 years when it's going to cost us another $100 grand. Not a good idea. Not in the association's best interest. And if you explain it that way to the members, instead of just saying, well, we don't want to have to tell the members they owe more money, then they might not be so upset about it. But here are some things that go into the budget. You adopt your budget with 14 days notice. Let's see. I'm going to skip through some of this. Reserves are very important. I have a class coming up on May 12th about the specific statutory reserves that are now required. There are mandatory reserves that you won't even be able to waive, even if you want to. But essentially, these are some terms. Capital expenditure is purchasing and replacement. Deferred maintenance means it's something that you do less than every year. And then we get into what is a reserve. A reserve is basically putting money away for a specific asset that's expected to fail or require replacement less than once a year. Okay, this is the statutes previously included roof replacement, building painting, pavement resurfacing, and anything else that has a deferred maintenance expense or replacement cost exceeding $10,000. Okay, we've got a huge amount of information that I could share with you. My suggestion, if you're looking for more information on these structural integrity reserve studies or milestone inspection reports, go to our website at KBR Legal, go to the resources tab and find Rembaum's Roundup and find Jeff Rembaum's most recent legislative update. That's going to contain all of the information on what you need to know about those structural integrity reserve studies. If you want it in a class, I will be teaching a class on that specific issue, on reserves in particular, and those studies in particular, with True Group on, I think it's May 12th. All right, so you can go on our website, register for that class, but that way we can skip through some of that right now and get to some of the other information that I also think is important. I'm not implying that I don't think those are crucial issues to your association, but there's statutes that are in play right now that will probably be changed before I even teach that class that will go into effect July 1st. So I really think that it's important enough to justify just attending that additional 1 hour class and getting the information there. Computing reserves. So it depends whether you're going with a straight line or a pooled reserve. Either way, you're calculating it the same. The amount you need for a straight line reserve is the amount that asset will cost to replace or repair, divided by the number of years you've got left of useful life. If you've got a $100,000 roof that's got 10 years left on it until you need to replace it, then you need to put away 10 grand a year. Now you can adjust for inflation, or you can go out every couple of years and get what's called a reserve study. That's what a structural integrity reserve study is. It's just specific components that are being evaluated there. But any reserve can be the subject of a reserve study to determine, okay, is this $10,000 figure still accurate, or are we really going to need 15 a year starting in year 3 until year 10? What about year 6? Okay, things like that. So you can increase. It doesn't mean that you can only put away that 10,000. Now, a straight line method is for every single asset, you have a separate accounting, and you're putting away exactly that number every year. In a pooled reserve, you're basically combining everything together and making sure that as each component is expected to fail, that entire pool has enough money to cover that particular component. It's a little bit different. You're probably going to want to get with your accountant on that. But my understanding is that pooled reserves basically don't require you to put away quite as much each year and might be beneficial if you're allowed to use them for the particular reserve in question. Waiving or reducing reserves is basically a majority of a quorum of the owners for most items. for the structural integrity reserves that the association is going to have to probably maintain, depending on the size of your building and the age of your building. Keep in mind that might be something you can't vote to waive or reduce going forward. So again, I'm not going to get into a lot of detail about this, but we will talk about it at the webinar that's coming up on the 12th. I know that is an issue that a lot of people want to know about, but I think it's crucial enough to separate all that out. And frankly, it allows me to skip through a lot of all of this stuff right now. The financial reports need to be provided to the members no later than 120 days after the end of the fiscal year. So keep in mind, when you've got your financials, you need to deliver those. You don't need, it's not just, well, we compiled all the information, now we've got the report, good for you, but you still need to provide it to the members. Okay, and that 120 days is a max figure. It really needs to be within 21 days after the financial report's completed, either by the association or received from the accountant or CPA. Okay, so just understand, you do need to provide this financial report to the members. It's not just, let's get it done. We've got different levels of financial reporting. I mentioned, I usually talk about the mo money, mo problems rule. That's what this is right here. The more money your community generates and brings in, the more reporting is going to be required. And that makes sense. You know, if you've got 150, let's say you've got $50,000 in revenues for your entire community, why the heck would you need an audit that costs another 10 to 20 every single year? And I've actually heard audits costing up to 50,000, depending on how many years are compiled together of records. An audit is basically reviewing every piece of paper in the association official records. That's why it's expensive. Your CPA is going to do that. When you talk about the report of cash receipts and expenditures, that can literally be a spreadsheet with brought this in, here's the dollar figure, here's the date, spent this dollar figure date, here's the general concept of what the expenditure or the income was for. And as you gradually get up in dollars, it becomes more and more likely that someone is taking a closer look at what is actually in these records. So I won't go through them in detail, but that's the general idea of what we're looking at. You should know based on what your dollar intake is, which is presumably based on your budget, you should know exactly which one of these you need and to be able to hire the appropriate professionals to take care of them. We're not going to have time to go through this stuff. And I did mention earlier, you've got my email address on here. Please hold the questions for the Q&A. But if I don't answer your question, I genuinely welcome you to reach out to me if I'm not able to get to your question during the seminar or the Q&A today, because I know that there's 186 slides and we don't have time to go through all of them. So if you see something in these slides after you get them from completing your survey and clicking on the link to download them, if you have questions, truly feel welcome to reach out, and I do my best within a day or two. For clients and potential clients, I generally respond within 1 business day. These, I get so many emails at the same time that chances are it'll take me a couple days to get back to you right now. Meeting minutes is an important concept. Every meeting of the board, every meeting of a committee, every meeting of the members should result in meeting minutes. That doesn't mean you've got an entire transcript of the meeting. It means that these are the agenda items. Here's what happened under each. A motion was made. This person made it. This person seconded. Forget about the discussion. I don't want verbatim discussions on the record. Okay. This motion was made. It was seconded by this person. It was voted upon in this way by the members of the board, or the members of the board abstained from voting. So that's all you have. And if it's, let's say, everyone voted unanimously, you can just put, instead of naming names and how they voted, unanimously, yay. Vote passes. Okay, it's that simple. But you should have how each person voted on the meeting minutes. You do not need a verbatim run through of everything that was discussed, everyone that raised their hand and spoke during the meeting. Unless there's some special reason that you need that on the record, it doesn't go on there. So someone trying to voice their opinion for the record that isn't a director, from my perspective, that is an exercise in futility. Other than that, the board members will hear what you're saying and hopefully incorporate it into the way they vote. Outgoing board and committee members need to return all official records and property of the association in their possession or control within 5 days after the new board and committee members are appointed. This is an issue I almost always have a problem with, unless the records and physical items are all with the manager. And when you switch management companies, by the way, there's a separate timeline that does apply to that same concept, that they have to turn everything over. Now, hopefully you're not leaving Sentry, but there are some that I will not name that I've seen reasons for people to leave, is all I will say. So when that happens and you're deciding on, let's say hopefully a better management company for you, you're deciding to go with Sentry or one of the other good ones in the industry, that former management company might be a little hesitant to give up your records. You have the right to those records. The association has the right to those records from the former directors and officers as well. And there are penalties for failing to return those records by the division. So if someone doesn't report it, you have your attorney send a demand and you send something to the division saying this person's off the board, they won't return the records, please penalize them. You're going to put it in a little different terminology, but that's really what your letter is saying. The association has the right to access units for the protection of common elements or other units. You do have the right to enter a unit. There is no requirement that you provide prior notice, although that might be a good idea. Okay. The other thing you have the right to do is access abandoned units. There is a statutory definition of what abandoned means. Okay, so you can't just go in and pull everything out without notice. You can enter to check for problems. You can't just enter without notice and remove a bunch of stuff. That's called theft. If you're removing it because, for example, we recently dealt a couple months ago with a hoarding situation in a condo, and there was a roach infestation as a result of the hoarding. Well, the association was allowed to send a demand to resolve the hoarding, and if they didn't do it within, let's say, the 10 days that's provided, the association had the ability to enter into that unit, remove all of this hoarding crap, clear out the cockroach infestation, and make sure that none of that was going to impact other units, which it had started to. Okay, so that is a right the association has. Again, try and provide notice. I'm not saying you shouldn't. I'm saying you don't have a legal obligation to provide advance notice if it's just for the purpose of checking. Let's say there's a water leak. You're certainly not going to give someone 48 hours notice before you walk into that unit and say, we need to shut this down. Okay, but just be careful as to how you do it. Get guidance from counsel before you enter into anyone's unit. And for God's sake, make sure that there is some kind of record, a video that is being taken of everyone that walks into that unit and what they are doing, so that you don't get accused of theft, even though you didn't steal the $50,000 in cash that they had sitting on the counter, which was never there. We talked about the Marketable Record Title Act doesn't affect condo covenants. Deeds refer back to the declaration, so you don't have to worry about it. You do need to let process servers into the community when they're trying to serve documents in a lawsuit. We talked about rules and regulations. Again, that's a 14-day notice before you adopt them. Rules can't conflict expressly or by implication with the language in the declaration, articles, or bylaws. The other thing to look out for, and one reason that I say you should really have your attorney take a look at these rules and regulations before they're adopted, is that even if the intent was completely genuine and you had no intent of regulating different races, different groups, different ages differently, you might end up getting hit with a discrimination claim because of the disparate impact of that rule on different groups. One example is, and this is actual Florida case law, there was a distinction between when men and women were allowed to enter into the pool in a community. And from all appearances, on the face of the rule, it looked like, yeah, everything's fine. You know, we're just saying men and women need to be separate. This was not a trans issue or anything like that, or an identity issue. It was just a, hey, men and women are separate. Well, it turns out that men ended up inadvertently getting an extra like 5 or 6 hours throughout the day to use the pool compared to women. And that was discrimination, blatant discrimination, completely unintended. So you just need to be careful and have your attorney take a look at those rules and regulations before you go ahead and adopt them if the board is the one preparing them. Better yet, have the attorney notified of what you want in those rules and have the attorney prepare them. The association generally has the obligation to maintain the building. You're going to look at your declaration to see exactly what that maintenance obligation is. But that will almost always include the common elements to keep them in a state of good condition. That's why I talk about the maintenance and operation of the community being covered in your budget. This is the maintenance part. Okay, you generally can't make material alterations without a member vote. This means you're visibly altering the condominium property, unless you get a 75% vote of the members or whatever votes required under your governing documents. There is an exception to that rule, okay? And you're going to want to get a legal opinion on this so that you are protected and you know that you are covered by it. But if you are making improvements to the common elements without approval, even though the documents require approval and the statute requires the approval, for the purpose of maintaining, repairing, replacing, or protecting common elements, you don't need the member vote. Okay, in this instance, it's the Tiffany Plaza is the case, and this was a rock revetment wall, which was basically that wall that's adjacent to the waterway that gets built up so that the water doesn't spill over onto the sidewalks and the grass. And it protected the condo elements, it protected the building. So it was found that the board had a maintenance obligation, and that obligation to also get a vote when you're doing the material alteration wasn't necessary if it's part of the maintenance obligations to the association. It's a lot more specific than I can go into during this class. I strongly recommend you run that by your counsel rather than just saying, well, Alan said during this class. No, that's not good enough. Okay, this is general information I'm providing today, not legal guidance. So just be careful not to completely rely on what I've said today. You want to shoot an email over to me and ask a question as a client of the firm, then you can rely on my guidance. But right now, what we're talking about, even if you are a client, is not legal advice. Anyway, we talked about what they are, what they might look like. Hurricane protection, one of the bills that was already adopted this year pertains to hurricane protection. You need to adopt hurricane protection specifications. We are in Florida, and you also need to allow people to put up hurricane protection items in your community. There are funds that are suddenly available for this purpose from the government. If you want to take advantage of them, I think it's called the My Safe Florida program. Something of that nature, but it is one of the bills that was signed by the governor last week, and it created a program to provide grants to community associations who wanted to better protect their infrastructure, better protect their buildings from potential hurricanes. So you might want to look into whether those funds might be available to your community to better protect your buildings. Moving on, emergency powers are something that comes into play only when a state of emergency is declared in the area, and it might cause damage to your common elements, your members, etc. Basically, damage or injury. Okay, this used to be only really intended for hurricanes, then COVID hit. Now it is any injury. It doesn't have to be a physical injury. It can be an illness, can be a pandemic, but it must be under a state of emergency. We won't go through what these specific rights are, but they are essentially created by the statute that's mentioned here. You'll want to look at them, and frankly, my suggestion, in your emergency kit for hurricane preparedness, have a copy of this printed out and available to you so that you know exactly what rights the association has. The materials for this class would be great, but what I'm really referring to is printing out a copy of this statute mentioned here, because it's going to give you rights that you wouldn't think you have. And if your attorney is not one like me that's going to be accessible during that hurricane or after the hurricane, you want to make sure that you have at least the minimal information you can use to make decisions for your association during that scary time. So we'll skip through what those powers are, because frankly, that's helpful to skip through some of the information here. Here's some more information, what you should have in your emergency kit that I just mentioned. I really do think every director should have an emergency kit pertaining to their own safety and the condominium itself. But in addition to all this, please get an external battery that is solar charging. It can be so useful. Beyond charging the walkie-talkies we're talking about here, you might have it charging your cell phone that otherwise dies after a day. You might have it charging your laptop that you might still be able to get access to the internet on through your cell phone. You might be charging these walkie-talkies to communicate with other members of the board, or if you've got an on-site manager who happens to live in the community, because frankly, I wouldn't expect an on-site manager to be on-site in the middle of a hurricane. You've got the ability to communicate and maintain operation during this scary, scary time. Leasing and approval amendments is another one that we have a class on, so I won't go through this in detail, but bottom line, keep in mind, not all amendments will apply to all members of your community is the big feature there. Amendments, if the declaration is silent, you need 2/3 vote of the members to amend your declaration, articles, or bylaws. There is a format that you need to use. I won't go through it because frankly, your attorney should be preparing those amendments. And the amendment is effective when it's recorded in the county records. If you don't think you can get the vote for a substantive amendment, one of the useful tips that I'll provide today, start by amending your quorum, make it less than the 50% or the majority that's statutory, and start also by amending the amendment provision so that you don't need 2/3, you need a majority of whoever shows up that meets a quorum. That's a lot easier to get than doing this. And add into that electronic voting, which makes it easier for those people to show up as well. So these are things that I've seen successful where, the substantive amendment might have failed otherwise. There are circumstances where not that you have to have a CAM, but that any manager you're using for anything beyond just administrative responsibilities does need to have a license. If they're being paid and the association has more than 50 units or a budget in excess of 100 grand, that manager must be licensed. If you're working with a management firm, it's on them to figure that out. If you are hiring a CAM directly on site or hiring a CAM that works remotely directly, you need to make sure that they are licensed if they're doing these things. Okay, the list is right here. I won't go through it. Keep in mind that the manager, the officer, or the director can't buy property at an association foreclosure sale. That doesn't impact a mortgage foreclosure sale one bit. So keep in mind, yes, we're saying you can't buy at the association's foreclosure sale. The lender foreclosing a first mortgage, a second mortgage, whatever, a tax lien sale, the association's directors and officers and manager are absolutely authorized to purchase at those sales. That's a question I get somewhat frequently when you have a unit that has a decent value. I won't go through this. Debit cards, don't use them. You can use a credit card in the name of the association. That's about it. Don't use a debit card. You can't. Okay, if it's not a lawful obligation of the association, it's credit card fraud, whether it's really fraud or not. So don't use those debit cards for association expenses unless you want to just take on the expense. The association can't hire an attorney who represents the management company of the association. This is one reason that we haven't asked Sentry if we can represent them and work with them directly as counsel. We provide them plenty of guidance, but if we did that, we wouldn't be able to work with any of Sentry's condo clients. Now, I don't like that idea. So keep in mind, we work with the management firm. We represent the association. I can say that for our firm. We don't represent the individual board members. We don't represent the individual owners. Okay, unless there's a weird situation. But keep in mind, if you're working with our firm, we're not working for management. We're not working for the directors. We're not working for the board. We work for the corporation that runs the association. Condo, electric, and natural gas vehicles. This is a 2018 law that basically says you kind of have to allow people to install these energy saving devices or energy devices. So just understand certain things regarding the electrical and natural gas fuel vehicles are going to be, you're going to have to allow them. You can require that they pay for the installation for the most part, but you're going to have to allow those charging stations. The other thing, and there's a lot more that goes into this. You can see I'm skipping through a bunch of slides here to save some time because we're at 12:56 and I still have 75 slides. But just understand the other thing that you need to know is energy efficient devices is another separate concept that's related to this. The association can't say you can't have a skylight just because it's a common element roof. Okay, the association owns and maintains the roof. The owner owns the unit. Well, they can still put solar panels up there. they can still put a skylight up there. Any energy saving device is something the association must allow. What the association can do is require that they sign an agreement that says that if the association loses a warranty on the roof, if the association has to repair the roof, if the damage that's caused to the roof causes damage to other units or other common elements, the owner is going to be legally responsible for all of that. And that the owner needs to maintain the panels and remove them and repair the roof if anything ever says that the association has to have them removed. For example, if you're going to replace or maintain the roof and the panels are going to last longer than the roof will, the owner is going to be obligated to pay the cost of removing, storing, and reinstalling those solar panels every time that that roof is repaired. So you can have that kind of restriction to protect the association, but you can't say no to the request overall. You can place conditions on the approval is about it. Disputes, we have an entire covenant enforcement class. This is one of my favorite subjects, and I hate that we don't have time for it, but we don't have time for it. But the bottom line is finding is a waste of time. It doesn't accomplish anything. Go after the owners who are violating your covenants. This is one of the 6 policies that I mentioned. So I guess this is number 3 for the day that every community association in Florida should have is what happens when people don't comply with your restrictions. It is a covenant enforcement policy. It's one of the 6 big ones. Okay. There's a reason I got certified as a mediator, by the way. I don't like the arbitration provisions of the Florida statutes. Fortunately, now you have the option in condos to either go to arbitration or meet pre-suit mediation. I find that the arbitrators tend to be less consistent than judges. They tend to reduce the attorney's fees exorbitantly. So they're reducing the fee to $200 for an attorney that charges $300 an hour, because that is the lowest common denominator throughout the state. So for some reason, they think that lowest common denominator is the appropriate amount to charge. And they'll cut hours as well. It's mediation. The parties sit down, you try and settle it. If you can't, you go to court and you're done. That's it. It's not, let's let someone else that isn't a judge make a decision for us. And then if we don't like it, we have to appeal it to a judge. I'd rather go straight to the decision maker. So moving forward, an important concept, your fees and costs incurred in enforcement. Most communities see that as a cost of doing business. I see it as an opportunity for an amendment to your governing documents so that the member is responsible, the unit is responsible for all of those attorney's fees and costs, regardless of whether a lawsuit's ever filed. That way, the owner that caused the problem or the unit that caused the problem is going to be held directly responsible for that payment of the fees and costs, and not the entire community covering that cost as a business expense. So that's an amendment that I think if you don't already have it in your governing documents, I'd strongly suggest the board consider, because it's only going to benefit your community to be able to do this work, knowing that you'll either get the money back or you'll be able to foreclose the unit. So we're going to skip some of this. I talked about some of the more important stuff, but again, we do not have time for everything, and I want to try and get done by 1:30 today so that we can do some Q&A. So the offer for pre-suit mediation is a letter that is statutorily prescribed. I'll go back to this. It essentially says you have 20 days to respond to this letter and agree to mediation with one of the mediators we've selected, or you've waived your right to attorney's fees and costs. That's another reason I like this. Okay. Even if the association loses at the end, if you lose in arbitration, you pay fees and costs. If you lose in mediation and the owner didn't respond and agree to mediate, if you send your offer for pre-suit mediation, they don't respond or they don't participate in the mediation process, they've waived their right to attorney's fees and costs in that case, even if they win, which is a huge boon for the association to not have to worry about that when you're going forward, paying your own attorney's fees and costs and the other side's charges. All right, moving forward, we're going to skip through some of this. Arbitration, like I said, it's with the division, which is a state entity. But I found over the last very recent years that they're very haphazard in the way they decide things. They don't really follow precedent other than whatever's in their own heads. And I've seen arbitrators that ruled with the same parties ruled differently on the exact same situation. Different parties, same community, same situation, no distinguishing factors. and the same arbitrator ruled differently from 1 month to the next. I just think that's ridiculous, and that's not someone I want to be in front of. Okay, association websites is our next topic. If you have 150 or more units, you need to create a website for posting association documents. Now, it was to be operational before January 1st, 2019. If you haven't done it yet, I can't believe no one's come after you for it. So please do it now. You should have, in my opinion, pretty much all of the association records on that website. There are some requirements that are potentially coming into play, depending whether the governor signs or vetoes the bill that is pending. I believe it's on the governor's desk now, but it would require a website for smaller communities than 150. I think it was 25 or more units. And it would also require certain things about the way that the association records are stored and produced. And that might be impacted as well by whether the governor signs or not. As of right now, I'm just recommending, because at some point it will be required that you put all of your records online behind login credentials. Because at that point, for the most part, you can just say, if you get a records inspection request, policy number 4, by the way, records inspection requests, how are they requested? What are you going to produce? What do the owners need to pay in order to get those records, etc.? But all of that is going to need to include, you're going to want to include all those records online so that you can just direct them, for the most part, to everything you're asking for is available on the portal. That's your entire records inspection. Have at it. Now, you may or may not be able to do that now. You may or may not be able to do it within the next few weeks. But keep in mind that, you know, it can't hurt to have those records digitized and available, even if you need to provide a physical computer for them to review the website and review the records and print them out. Association website needs to be independent and owned and operated by the association, or it needs to be operated by a third-party provider with whom the association owns, lease, rents, or otherwise obtains the right to operate the web page or collection of subpages, blah, 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 on which their records can be posted. If you're required to have it, you need to also post meeting notices on your website. So when you have those 48-hour notices, the 14-day notices, they all go on the website as well. It needs to be accessible through the internet and contain a web portal or other protected electronic location that's inaccessible to the general public, meaning that your records are not just your official records accessible to me and everyone else in the world. It's only accessible to the members of the community that are authorized to receive those records. Association does need to provide login credentials. You can't just say you're delinquent, so you can't get onto the website. It doesn't work that way. You can say you're delinquent, you can't get your ledger, but you can't say you can't get onto the website and access all of the records. Let's see. These are the documents that need to be included. I'm not going to go through them in detail because you're going to have the slides and that'd be a waste of your time. You can read it just as well as I can read it to you. Same thing here. Notice of all the board meetings, agendas I mentioned. Failure to post the documents on the website is not an invalidation of any action or decision of the association. It just means that you did it wrong and you might get slapped on the hand. You need to ensure that the information is not accessible to unit owners isn't posted on the website, or it's behind separate login credentials that are only accessible to the board and council. In complying with the requirement, there's no liability for inadvertent disclosure of that information. So if you've got your records online and somehow the wrong record got into the wrong portal, no harm, no foul, but make sure to pull it off as soon as you find out that that's an issue. You can adopt rules for conspicuous posting of meeting notices, like I said, and it needs to include a requirement that the association send an electronic notice, in other words, email or fax, in the same manner as a notice for a meeting of the members, including a hyperlink to the website where the notice is posted. In other words, instead of me emailing you a copy in a PDF, you click a link and it pops open in your browser. Now, this basically says that instead of having a website, you can have an app. Simple as that. Your official records. Again, there's a nice little list here. It's great, but here's why I'm not going to waste my time reading it to you or waste your time. Number 14, all other written records of the association not specifically listed, which are related to the operation of the association. What does this mean? Every written record pertaining to the operation of your community needs to be in those official records. The association maintains the records for 7 years, except board certifications are at least 5, or as long as the director serves, and election materials are until the next election. However, certain things need to be kept forever. So don't get rid of any of it, because you never know what the legislature is suddenly going to decide. You need to keep this forever too. Oh, well, how? We don't have it. It's already gone. You told us we could get rid of it. We did it. What do you want from me? So that would be your answer, but you don't want to have to worry about that. So bottom line, keep all these records, keep all written documents, whether it's electronic or otherwise, that pertain to the operation of the association. Now, the questions I tend to get, what about the video of our meetings? We record those. The Florida Administrative Code governs that issue. If you're only keeping them until you create the minutes based on what the content of that recording was, it's not an official record. It replaces the meeting minutes until they're created. Then you can destroy the video. Okay, you don't have to keep those meeting video records. If you keep them forever, then they become official records. So my suggestion is, unless you have some reason to keep a specific video, have a policy written and in place that says we're going to destroy these records as soon as the meeting minutes are prepared and adopted. Done. Another one that I get is, are emails between directors or between directors and the manager subject to inspection? That one's kind of iffy. The DBPR has said yes, they are official records and need to be provided. I still think that makes no sense, because how is it an official record of the association when, just like having a meeting that isn't a board meeting, no business was conducted. It's not a record pertaining to the association business, but better safe than sorry. So the answer is yes, you might want to put all of those records into the official records of the association. Another suggestion, if you're using your email address for purposes of association discussions on behalf of the board, on behalf of yourself as an officer of the association, make sure to create a separate email address so that when there is discovery in a lawsuit, nobody has to go through your personal emails to try and find the relevant information. And also so that when you have a new director step into that role that you were in, you can just hand off the login credentials to them and you've delivered everything you have. Done. I don't need it anymore. You have at it. What I have seen some people do is save a copy. So like take Outlook, save the PST file, and still pass along without deleting anything. But that way you at least have a copy of all the communications you had with other people pertaining to the association. Renters have the right to copy the governing documents. Everyone else has the right to inspect and copy all official records, except all of these. So the biggies are attorney-client or work product privilege information regarding litigation. Some people will say that that privilege only extends until the board waives it, which I agree with, or until, and when I say the board waives it, by the way, I don't mean an individual director says, we don't need to keep the privilege on this. I mean the board actually voted on that issue. The other time that I see and don't agree that people say that that privilege ends is when the litigation in question actually ends. Pardon me. My perspective is, okay, well, I could have a judgment and 5 years later, someone could try and vacate that judgment and use that privileged information in further litigation. Or I could have a situation where someone dismisses their case. We don't have a settlement agreement. They just agreed to dismiss the case. And now 2 years later, they're filing a new lawsuit about the same issues because the judge never adjudicated the issue. There was never a resolution of the issue. And now all of these records have been made available to them. Do you think that might incentivize someone to dismiss the case, pay the attorney's fees that the association spent, and then have all of this privileged information regarding the association's strategies and things of that nature to use in the new lawsuit? Do you think that might happen occasionally? So my perspective is that privilege lasts until the board says it doesn't. But other information that should be kept away from people asking for records inspections, information regarding leases, sales, or transfers of ownership, medical records, personnel records, and I don't mean management personnel, I mean association personnel records, association passwords and software that allows for manipulation of data, because You're going to produce a PDF rather than let someone go into QuickBooks and change around a bunch of association information. Social security number, so personal information of the owners, which the owners can choose to disclose, written consents, and then keep in mind an owner can consent in writing to disclosure of anything that's in here if it pertains to them in particular. And good news, if you inadvertently disclose any of this, there's no problem there. If it's inadvertent that you disclose it as an association, things that should not have been accessible to the members. We talked about attorney-client privilege. Only the board can waive that privilege. Let's get into how to request these records. Again, this is one of the policies I think every community in Florida should have to govern how to deal with these. But generally speaking, the records within 10 business days after the request is made in writing. That can be email, it could be a letter, it could be a fax, whatever it may be, but in writing, if it's requested, then within 10 business days, the association needs to produce all of its records within 45 miles of the community or within the county, okay? And when I say the community and the county, I mean the community, the condo, or the county where the condo is located. Now, the right to inspect these records includes the right to make copies of them. The association doesn't have to go in and cherry pick the records to produce specific items. So if they say, I want the financial records from 1992, well, one, we don't have those anymore. But even if we did have them, we don't have the obligation to go into our records and say, here's this particular document you were asking for. Right now, the association's obligation is only to go through the records and produce everything. It's the owner's obligation to find what they're looking for within those records. So some communities have 30 boxes of documents and they say, here, have at it. Now, I would recommend that someone be observing to make sure that these people don't take anything out of those records. But generally speaking, you don't have the obligation to cherry pick anything for them. You also don't have the obligation to create records for the owner that's requesting them. All right, so we talked about rules. That's establishing the policy governing records inspections. If you don't provide the records in time, there is a rebuttable presumption that you intentionally failed to comply with the request. When I say within the right time, I mean 10 business days after receiving the request. That will entitle the requesting party, if they are entitled to the records, to $50 per calendar day, up to 10 days, starting on business day 11. I call that the $500 gift because it goes up to $500 plus the attorney's fees and costs incurred in getting that money and getting the records. So my suggestion, don't create that rebuttable presumption that the association willfully failed to produce the records. Just send an email, send something in response saying your inspection is scheduled for this date and time at this location. If they can't make it, great. You've still complied with your obligations. It's on them to figure out whether they need to submit a new request or what. But at least you've done what you're obligated to do, and that $500 is not something they're going to be entitled to. Email addresses and faxes are not subject to inspection unless they're provided to fulfill notice requirements, meaning email notices to the members, or the owner first provides the association with written consent to disclose it. No penalty for inadvertent disclosure. Contracts and bids, we're going to breeze through, but these contracts need to be in writing. Maintenance contracts, in my opinion, should always specify the obligations of the party contracting to provide maintenance or management services, the cost that's going to be incurred for each service they're going to provide, the scope of what they're going to provide, the frequency that the service is going to be performed, the minimum number of personnel that are going to be employed for purposes of providing the service to the association, and anything not specifically stated in the contract that is not going to be an enforceable obligation of them. So you really want a clear contract. This is why I say, even if it's your landscaper, spend the money to have your attorney make sure that the association is entitled to attorney's fees and costs in the event of a breach, that there's a termination provision if this is not a month-to-month provision, so that you're not stuck with a year of a crappy vendor, things of that nature. Okay, you want to make sure that the contract is actually not completely one-sided, like a lot of construction contracts I see. You want to make sure the association's protected. What warranties are being provided for the service that's being performed? What guarantees are they providing if they cause damage, that they're going to cover the cost? If they damage another unit, if they damage common elements, are they going to pay to repair that? Or are they just going to say, well, sucks for you? Okay, keep in mind, these are all things that your attorney should be looking into and making sure are included in your contracts, and they're not going to be included in most of the, I call them estimates, which is not a contract. If you have an estimate and it's for 50 grand, you should be having your attorney prepare a contract. Even if it's for 10 grand over the course of the year, my opinion is you should be having your attorney prepare at least a minimal contract that says what this person's going to do, when they're going to do it, how and how much they get paid, and what happens if they don't. Because that consequence is what is not included in any of those estimates. And so if they violate their own estimate, they use different materials. The question is, well, what remedy do we have available now? And then you end up trying to settle with them rather than saying, you've breached the contract, we're going after you for it. If the aggregate cost of any one project exceeds 5% of the total annual budget, including reserves, the condo association must obtain competitive bids. That doesn't apply to contracts with employees or professionals of the association, or if there's no one else in the area, in the county, that actually performs that work. If you have no one else in the area that's going to perform the work, you just have the person that's willing to do the work. If you have less than 10 units, you can opt out of these bidding requirements if 2/3 of the owners vote to do so by a proxy, specifically setting forth the exception from the bidding requirement. You don't have to accept the lowest bid, guys. You don't have to say, well, John is cheaper than Jim, and so we're going to accept it. I don't want the cheapest brain surgeon. I want the best brain surgeon. I don't want the cheapest cardiologist. I want the best. That's what you should be doing with all of the professionals listed here. The association managers, the attorneys, the engineers, the landscape architects. You want to go with the cheapest landscaper? Fine, that's okay. But if you're going to do that with your attorney, chances are you're not getting the level of service or expertise that you might expect from your lawyer. Same thing applies to management. So yes, you can go with the cheapest if they're also the best for your community. You can cancel certain contracts by unit owners. We'll skip through that, but just understand that the members have the right to do that. It won't come up unless it comes up. And if it does, make sure that you're coming to your attorney to get an opinion. Same thing with bulk communication contracts. And I have 40 slides left, so I'm going to skip through a lot of this. But you should run all of these bulk contracts by your attorney. Assessments and foreclosures. This is where I started with the firm and in the industry. We do have a separate class on it, so I'm not going to go through it in detail. But this is another one of the policies I think every community should have is what happens when someone doesn't pay on time? What are we going to do? And all of these policies that I recommend automate these processes so that the board has as little work to do as possible to make sure that the association is properly taken care of. But there are some things in here that I think are valuable. I think that you should be reading through all of it, but I don't have the time right now. I mean, again, this is an hour-long class that we teach. So what we talk about in this section is essentially the association, the right and ability of the association to go after these unpaid assessments, what the process entails, what mortgage foreclosures look like, and what you can do to move them forward if they're not moving forward. And then we talked about rent demands, tenant obligations and remedies. Receivers and receiverships are something I hope you never have to deal with because frankly, it's an added cost. And then bankruptcy is another issue that's not addressed in the slides, but is addressed in our separate class. Again, you're welcome to check that out online for free. You don't even need to email me and ask me for it. Just go to our website under the resources tab. Insurance is another issue I see coming up fairly frequently. We talked about the directors and officers liability policy. You should also have a policy regarding damage to the condominium or injury to others on condominium property that the association might be responsible for. You do need adequate property insurance. What is adequate is basically whatever's in your best efforts to try and maintain that would replace or repair any damage that occurs on the condominium property. Okay. If it's caused by intentional conduct or negligence or failure of someone that is not the association to comply with the terms of the declaration, keep in mind the unit owner is generally going to be responsible for the cost of repairs and replacement. But if it's covered by insurance proceeds, great. If it's not covered by insurance, you might be able to go after the responsible owner. The unit owner is responsible for the cost of reconstructing a portion of the condo property for which the unit owner is required to have insurance. So keep in mind, I see a lot of these cases and I mediate a lot of them where a unit owner is going after the association for alleged negligence, for failure to maintain the common elements. But the cause of the damage was a hurricane. Well, sorry, but no, I don't think that you're entitled to that under the statute. The statute says it was your obligation to ensure the contents of your unit, including flooring, the kitchenette, all of the other things that might be in the unit, your damaged couches and all of that stuff. That's all your responsibility as a unit owner, not the responsibility of the association to insure. So my perspective is if you failed to maintain that insurance, it's probably on you to pay for whatever it costs to repair that. The association repairs what's considered the common elements within the declaration. That's the extent. So it usually is going to be, we'll repair the drywall, we'll clear out any mold within the walls, but anything beyond that, if you want that drywall repainted, if you want to fix the flooring in the unit, that's on you. Fidelity bonds is another thing. Anyone who controls the funds of the association or disperses the funds, the association has to have insurance or a fidelity bond for that person. It needs to cover the maximum amount of dollars that that person's responsible for or controls. So this is just one of those things that a lot of people don't seem to know about that you should be keeping in mind. Presumably your manager is going to help you to take care of that because they're going to be one of the people or one of the groups that's going to have that level of control. We talked about the responsibility to insure. We're going to kind of skip through this. Again, Fair Housing Act. This is the disability related requests. Another policy I think every community should have. Let's see. We're going to skip through this because again, we have an entire class on it and we're already at 123. And I think we might have one more section, which is recalls to go through after I skip through this. But again, you're going to have a lot of information regarding this issue. But if you're interested in these fair housing issues, feel free to reach out to me or to watch our fair housing class, which has a ton of information. Recall is one that we don't have a class on, so I'm going to go through it in a little bit of detail. But the bottom line is, it is basically a vote of the members to remove someone from office as a director, regardless of whether they ever did anything wrong. It has nothing to do with, you did this wrong, so you're off the board. This is, we want you off the board. I don't care whether you did anything wrong or not, period. If a recall succeeds, that director is off the board, period. Now, the way that you can accomplish a recall in a condo, and this, by the way, other than for cause with the statutory provisions, this, in my opinion, is the only way to pull someone off other than through an election. If someone's on the board, they're on the board for the rest of their term, unless they do something that is statutorily prohibited and will have them removed under the statute. This recall is a special member meeting to recall directors, which is 10% of the voting interest, just like any other special meeting, will put in a petition and say, we want a recall meeting. You can't use electronic transmission to provide notice of this meeting. Okay, that meeting needs to be held shortly thereafter. Okay, a recall by written agreement, on the other hand, is a majority of the members have actually signed a written petition. Okay, at that meeting, the only decision that gets made if they got a written petition is whether to certify the recall based on whether the procedure was valid. In other words, whether on the face of the recall petition and on the face of the recall ballots, they're actually valid. If you've got less than a majority of the members, then you don't have a recall, period. Okay, the members can sue and say, well, you invalidated some of these ballots and we disagree. But generally speaking, that meeting gets held within 5 business days. And this is why I always say, if you get a recall petition or a request for a recall meeting, you need to get that information to your attorney that day. Okay, we've got 5 business days, and I've got some communities, like I said, there are 3,000 lots, 3,000 units, and that's at least 1,501 ballots that we might need to count to decide whether that recall passes or not. So you need to make sure that you're doing this the right way and getting it to the attorney immediately. Okay, if the recall succeeds, meaning that the majority vote was obtained, or a majority vote is obtained at that special meeting we mentioned, then the person is off the board. If the board fails to duly notice and hold the meeting, then the recall is considered effective regardless of whether it should have been or not, based on the vote not being taken, etc. Okay, Since the law changed in 2017, the board doesn't have to certify or not certify the recall. If either side takes issue with the result, you can file a recall petition with the division or file a lawsuit in court. Now, the recall directors are removed based on a facially valid recall vote. That's all that's required. A facially valid vote. That's it. So this is highly technical, highly procedural, within a highly technical, highly procedural area of community association law and condo law in particular. So make sure, again, just get this over to your attorney the second you get it, is really the biggest piece of advice I can give. Now, the recall can be challenged by the person who was removed. A recall petition must be filed within 60 days after the recall is deemed certified, but that petition can be filed by the board member or the owners who filed the recall that was challenged by the association. No petition will be accepted if you are within 60 days from the date of an election meeting. Because what's the point? Either you just had an election, you challenge the election instead of doing the recall, or you're about to have an election and someone being pulled off the board doesn't mean anything. So chances are, if you're within 60 days before or after your election, so that's 4 months out of the year, you're not going to bother with a recall. Finally, I was wrong. We have one more thing, termination, and this is a highly technical aspect as well, probably even more technical than a recall, but it is essentially, it's not just a member vote. There's an entire procedure that needs to be followed in order to terminate a condominium in Florida. And frankly, it is way beyond the scope of this discussion, but there are two different reasons that you can do it. One is the association is in such disrepair. Let's say there was a sinkhole and you don't have a building anymore, or it's just not fiscally feasible to continue operating as a condominium. So you want to convert, you want to terminate the condominium and let someone buy this building and clean it up. Okay, so termination is something that we do handle occasionally. It's not something that anyone should be delving into for the first time as someone who doesn't really practice in this area of law. There are a couple attorneys within this industry that are phenomenal at it and focus on this area of condo terminations. But I have a feeling with all of the requirements that are coming into play within the next year or two, with reserves and reserve studies and paying a lot more in assessments, that there are going to be more and more communities that are no longer financially feasible to continue operating. And so there will probably be more terminations than we've seen in the past. So now that my voice is almost shot and I have an annual meeting next year, we are going to go ahead and stop sharing. Thank you all for your time. Has House Bill 1021 been signed into law, or is it effective at a particular date? I clicked already that I was going to be answering that separately. That is one that will, that's on the governor's desk. I mentioned that there are a few right now that are pending the governor's review. This is one of them. So we expect it to be signed into law within the next few days, but I can't say for certain because nothing is safe when the legislature is in session and nothing is safe when it's on the governor's desk. So let's move into the chat. Thank you, Jeff, for sending these over to me. We have Dan asking, I'm on the board of an association in Kings Point, Delray Beach. I'm responsible. Am I responsible, or can I be sued for any reason by an owner of a condo in my association? The short answer is yes, you can be sued for any reason. Whether you're actually held responsible for it is a different story. The bottom line is, if you didn't do anything that was fraudulent, that was specifically intended to harm one particular member as compared to any of the others, etc., that's not something that you would generally be held personally responsible for. It's only going to be something that you did that was really, really bad as a director that you should be held liable for. Otherwise, presuming you're making decisions based on your best business judgment, you almost never see a judge rule against a director for making a bad business decision, as long as it was a business decision and not an emotional one. Where you get into emotion is where you have people sending emails back and forth that say, I hate this woman. I can't believe she submitted another architectural request. I'm denying everything she sends from now on. Stupid things like that. Okay. If you're going to be stupid enough to make that bad decision, at least be smart enough not to put it in writing. But the bottom line is, I very rarely see people actually held responsible for breach of fiduciary duty, which is really the only thing that the members would be suing you for in your capacity as a director or officer of the association. Paul asks, how often must a board member be recertified? There is no recertification requirement right now. I will possibly have a different answer for you as of July 1st, but I don't know whether the governor will sign that bill or not. I'm hoping that he will. Florida estoppel fee elimination bill is set for legislation. No, that one was killed for this year. That doesn't mean it won't be brought back up in the next legislative session. So fortunately, that one was not passed. If we send notice electronically, do we have to provide electronic voting? No, those are two completely separate concepts. Electronic notices is just a replacement for your actual notice of the meeting. Electronic voting is a completely separate concept. So no, that it's not a one means both type of situation. They're not mutually exclusive either. You can do one or the other. It doesn't matter which. Generally speaking, if you're going to do electronic voting, you should be doing electronic notices, because otherwise people are going to get a paper notice of the meeting and then have to go to their phone or their tablet or their web-enabled device to go vote. James, the committee meetings must have an agenda and written committee minutes. Which statutes so state? Committee meetings, it's the same as the board meeting statute that will say whether a committee meeting requires an agenda and a notice or minutes. The only ones that are open to the members are going to be the ones, like I said earlier, where association funds are being spent potentially, or decisions are being made for the board. So those are the ones that need to be open. They need to have minutes. They need to have an agenda, etc. Any other committee meeting, from my perspective, could be exempted from the requirement that you provide notice and have an open meeting. If there's no open meeting, chances are you also don't need to have minutes, because all those committees are really doing is giving advice to the board that the board will then use to make its decisions, which will be reflected in minutes. Robert asks, our documents have a provision to remove directors, 10% homeowners petition and a 48-hour notice, 2/3 majority present, now 60%. My opinion is that's probably invalid now that the recall statute is in place, and that you would follow the recall petition provisions, not just what's in your governing documents. I don't like it. I think that it interferes with what's in the governing documents, but this is a procedural issue that is impacted by new legislation in most cases. So the opinion of the firm and my opinion is, if you are talking about a provision that is for removal of directors, that's only removal for the reasons that are stated in the statute or because of a recall. Frank, any changes to the requirement of being fully funded by 1/1/25? Can a condo reserve at the minimum level of 70%? Reserves are going to need to be fully funded. Depends on when you have your budget for the year 2025 enacted. So not really a straight answer, but there's nothing I'm aware of that says you can have your reserves at 70% unless the members vote for that before the full funding requirement kicks in. Brenda asks, can a finding committee meet virtually with the homeowner, or does it have to be in person? Generally has to be in person unless the owner actually asks to meet virtually. At that point, I don't have a problem with it. It's not something that's necessarily supported by the Florida statutes, but if it's what the owner wants and it's what the committee wants, why would it be a problem? And I don't see a reason for a problem. Daniela, are full reserves required by Florida law? Generally, no. You need to fully fund reserves unless the members vote otherwise on the things that are not structural. But on the structural reserves, there are certain requirements of Florida law that say you have to have the reserves fully funded. That isn't in effect yet for the 2024 budget, but it might be for 2025 or 2026. Keep in mind also, that's only going to apply to buildings that are 3 stories or higher. So it might be something that you don't even have to comply with. Ask your attorney whether this is something you need to do. Regarding hiring a committee, sorry, this keeps moving around. Must their decision with respect to sorry, this keeps moving and I'm trying to read it. Must their decision with respect to violations be unanimous? No. they get to vote, and the majority rules. So that committee, you don't hire a committee, it's a hearing committee. I hope that is what you meant. Let's see. Thomas asks if a member asks me as a director for information on HOA budget / spending, what's my responsibility? Can I simply refer to the manager? Yes. I mean, you're a director. It's not your responsibility to explain all this. And frankly, it's not the association's responsibility to explain almost anything beyond here. You can request to inspect the official records. The budget is there. It should show every expense that the association reasonably expects to incur. So it's a matter of, yes, you can direct them to the manager and tell them they can request to inspect those records if they want. You don't have to send them a direct response unless they submit a specific type of inquiry that you do need to respond to. Jeff asks, as an example, the community has a waste management issue and there are 4 out of 7 board members that meet to brainstorm solutions. Is that a board meeting that requires notice and owner attendance? Again, same answer that I gave before. That's going to be a, you have an issue, but you're talking about board members. It's going to be up to the attorney to give you to give you an answer on that. My opinion is if it's just informational, it is not a board meeting, and those directors can meet and discuss it as long as decisions are not being made. Not every attorney is going to agree on that. You're going to want to get written guidance from your specific attorney. Thank you, Emily, for the kind words. Stephen, can fines be retroactive to the date the violation started? No. You are going to have it be for the date that the board met. So it's not going to start as the first $100 that goes up to $1,000 after the fining committee meets. It's going to be after the board meets, but it's not going to be retroactive to the date that the violation was noticed. Joseph asks, what can a board do about an animal that runs loose in the community? Some members feed it but don't claim it. We don't know if it is vaccinated and doesn't have a tag. Call animal control is the easiest way to deal with that. If the members get upset about it, that's their problem. But it doesn't have a tag. You're not aware that it belongs to any member of the community. It should be removed if you feel that it's going to be a threat of damage to property or persons. And it looks like that's all we have by way of Q&A. I really appreciate Ashley and Sentry's time today and having us here. It's always a pleasure working with Sentry and with Ashley in particular. Jeff, as usual, thanks for your help. I hope that everyone got a lot out of this. I know that I deferred to other classes for a lot of this. That's not anything to try and, milk our firm. I don't make any extra money by saying, hey, check out our class. I won't even know that you watched it, frankly. But if you do have questions with respect to those classes, with respect to anything we discussed today, if it's regarding Kaye Bender Rembaum, me, the firm, the legal questions that come up, feel free to reach out to me directly. My email is here. It's in the slides. But when it comes to management, you're not going to find much better than Sentry. Feel welcome to reach out to whoever Ashley says to reach out to on that front. So I appreciate everyone's time today. Thank you so much for having me. Hope you got a lot out of it.
Thank you, Alan. I know you have some appointments to get to. We truly appreciate it. Great job as usual. I want to turn it over, before we go over the evaluation process one more time, our host and presenter for today, Ashley Northrop, Sentry Management. Do you have some parting words and how folks can reach you all?
Yeah, absolutely. So first, I just want to say thank you, Alan. Thank you, Jeff. We really enjoy when you do classes with us. Great content. I hope all board members today walked away with information that you feel more prepared to be a board member. If you have questions for Sentry Management or me and our team, my name's Ashley Northrop, Michelle Meyer, and Amanda Barnes are other team members on the learning and development team. You can contact us at learning@Sentry, SENTRYMGT.com. And we'll get back to you, whether it's just general questions about management, about the class today, about your certificate. We'll be hosting and offering other classes in the future as well. So if you're not on our mailing list, please feel free to do so. If you have questions about that, you can reach us there. So thank you again, Alan and Jeff. Really appreciate great class today.
Thank you.
Thank you very